Now that we have a quorum, we'll go ahead and get started with meeting number 20 of the Police Civilian Review Board. First, we'd like to start with the minutes from the previous meeting. Oh, first, I would actually note that Chair Jackson is not here. She's not feeling well, so I will be sitting in her place today. All right, first for our meeting minutes, has everyone had an opportunity to look over the minutes from last week's meeting?
Yes.
Do I have a motion to accept?
Second.
Any discussion? All right, motion pass, or all in favor, please say aye, or raise your hand. All right, motion passes, thank you. All right, next up, we have our social media policy, which was provided via email, but is also in front of you. I would just highlight the two things that were added by an ad hoc subcommittee made up of myself, Dr. Jones, Board Member Strickland, and Pastor Nathan. The additions are point number 2, and then also a footnote 3. Point number 2 says undermine the appearance of the collective neutrality of the board. Footnote 3 specifically is tied to impede or interfere with board requirements or that of a city employee. And the footnote references the board bylaws, code of conduct, pledge of ethics, rules and regulations, and other governing documents. So I'd entertain any questions or comments.
We need a motion to approve this.
We would.
Yes.
Motion?
It's been moved to approve and accept.
Second.
Second, all right. All in favor, please say aye or raise your hand.
Are we gonna have a discussion?
You can just, would you like to discuss?
I would like, yeah. Yeah, I just wanted to make sure we everybody had the chance to review this portion. The one thing, I was part of the subcommittee, the one thing I did want to bring up was this point number 2, this notion around undermine the appearance of the collective neutrality of the board. Would there be kind of further discussion on what that means exactly? I just want to have discussion on that.
Wasn't that your suggestion?
No?
I thought it was.
No, it was not. I think it might have been Pastor Nathan's suggestion.
So as Board Member Strickland noted, we did, so 3 of us here were in the meeting where we drafted these comments. Does any other board member have any question about its meaning or content?
Well, I was just waiting to hear it. Yeah.
Well, the conversation that we had was basically, the board was created, most of our bylaws and all of our governing documents suggest that we should review the cases without bias and do our due diligence of doing so. And so just basically this bullet point number 2 is just further emphasizing that point, that we would just, we would not do anything or engage in any activity basically on social media or whatnot, or in the media that would undermine the appearance of the collective neutrality of the board. So that means jeopardizing the entirety of the board in terms of having any type of bias or anything like that.
And it reiterates part of what's already in our professional code of conduct, which is one of the documents that we adopted earlier on in the process. I could reread those here, but I think we all have them. But the main focus of those is that we would undertake our duties in a manner that shows no impartiality, that we don't have bias, like everyone exists with bias, but that we're not utilizing those biases in how we're issuing our decisions, or we're not in our official capacity on social media making statements that would appear to undermine that.
And I think Pastor Nathan, what he was getting at was what Brooke just stated, but also the other governing documents suggest, like, on social media, like it's like a very specific. And so he said there was not a statement that explicitly states that we would not do anything basically to undermine the appearance of neutrality. So he wanted to explicitly put that in here.
Yeah, no, certainly. I think that makes sense. I like the footnote 3 that we talked about in terms of also incorporating the board bylaws, code of conduct, pledge of ethics, all the pieces there to emphasize that. It was just it was just hard in terms of determining what it means to undermine the appearance of collective neutrality when speaking their official duties. So I do want to highlight and underscore that. I think it's important that we have a policy in place, but just in terms of the other piece that was separately tabled, which is making sure that our board also has kind of thinking about what a discipline policy might be, so what violations of these policies would entail. So that's still under future consideration, but I also wanted to make note of that as well.
Yep, duly noted, we have a Rules and Regulations Subcommittee, of which you are now on. So you know that we will be talking about discipline, but discipline is not tied to any of our other policies individually, because we decided that discipline should be a standalone, because anyone could be disciplined for any number of the policies we already have. So it doesn't make sense to create a discipline policy attached to each and every set of regulations we already have in existence. Any other discussion or questions? All right, I think we already voted. We had one.
Just do the vote again.
Yeah.
Just to make sure.
If we could vote again, because I think everyone except Board Member Strickland voted. So all in favor of passing and accepting the social media policy as written, please raise your hand. All right, motion passes. Thank you. All right, so we had one case, and I at least want to start out here. I'm hoping that everyone, all the cases that are being reviewed today, if you had any clarification questions that you wanted to ask the IG and then the investigators, that you have done that prior to the meeting. So that way, if you've got questions that just require a quick clarification point, that you've had the opportunity to do that. If you have not taken that opportunity, just please take a second and take a look at your cases, because we want to make sure that we're discussing what needs to be discussed, which are substantive, but if there's something that's a quick question, please take note of that and maybe move that to the end of your list, so that way, if the IG can answer questions, we can give them a heads up on what that's going to be. Okay? Yes.
Are we, at this meeting, are we going to have a discussion about some of the recommendations and procedures that the IG's office submitted to us last week?
So I did not have a chance before Chair Jackson got sick to actually talk through with her if that was going to be a separate point. So I'd say let's table it till April in the event that that was not going to be on the agenda today. Is it? No. I didn't think so.
Okay, okay. Yeah, it was my understanding that that was going to be on the agenda, like, as part of the continued report, but is that, we're just going to table all that to April then?
I would, just because, I don't know that we have to have an official adoption of the recommendations. I think some subcommittees on their own took some of those recommendations into account as they prepared their reports, or tried to follow the outline that the IG gave. But again, because Chair Jackson, in her absence, I'm just going to say officially on that, we can wait till April. All right. We had two cases that were tabled last week. One of them was a case in which two of our subcommittees were both assigned. That's case number 2022-0424. Then there was a case 2022-0411, which I believe there was one outstanding recommendation or allegation that was left. So those two we'll address now, and then move on through our regular team presentations. So one of those cases, I'll say, on Team 1, we also looked at 2022-0424. If I recall from Team 3, you all agreed with the recommendation, if I remember correctly. Is that right? So did our team. Just as a refresher, case number 2022-0424 was filed October 26, submitted December 23rd. The complainant alleged excessive use of force after officers came to his residence regarding a custody dispute. He alleged that officers twisted his arm behind his back after he'd had recent shoulder surgery. He also alleged that the paperwork outlining the custody order was fraudulent. The investigation reflected that the court order was legitimate and that the officers involved took the complainant into custody with minimal force following the complainant's noncompliance and obstruction of their service of the court order. The investigation also showed no evidence to support that the complainant's shoulder was re-injured. The IG therefore recommended the allegation be closed as unfounded. Our subcommittee also agreed. So it looks like both of our subcommittees came to the same conclusion. Okay. Because I'm sitting as chair, I will not make the motion.
I will.
Thank you. Thank you. Any seconds?
Second.
All right, any discussion? All right. All in favor of moving to accept the IG's recommendation as of unfounded in case number 2022-0424, please raise your hands. All right, motion passes. Thank you. And Board Member Strickland, I'll turn it over to you for Resolution 2022-0411.
Is this where I would just want to get it looks like I've got here on my desk here an update from the Inspector General's office regarding this case that we had further questions on. It was -0411. So I see the update here with this information. I don't know if there's any further points you want to add.
Yeah, I have the investigator that handled that investigation is here. So he was going to present the answers, but what he provided was just a written paper, so if you want to follow along, but he will be able to provide all of the answers to some of the questions that you had. And also in the report, he will reference that some of the questions that you had is in the report. So he's going to reference the page number in case the committee wants to look at the report and look at where that information is referenced in the current report. But anyway, I'll have him go on and give you a quick update.
Thank you.
Sorry, it's Investigator Scott Hurley. And also, just making a quick announcement, yes.
Quorum anymore. So I don't know if he's just using the restroom or not, but there's only 5 of you here, so,
Pastor Tatum just arrived.
okay.
Do we have to call him in? Thanks for that update. That was good. I was about to say we're coming close.
And there can still be discussions, but if there's going to be voting and you want him to vote, he should be present for the whole discussion.
He's acting supervisor.
So you may want to have the IG start again.
Yep. Inspector General Hendricks, you can proceed.
Okay, so also I needed to correct myself also because we also hired a supervisor investigator, but we actually promoted from in-house. So Scott Hurler is also our supervisor investigator over our investigation.
Congratulations.
Thank you.
But he will give you an update on this case.
Thank you.
Thank you. Good afternoon, Vice Chair, Board. Member Strickland, did you have a chance to look over those notes that I had provided? I know I got them to you guys immediately before the meeting.
Yeah, I'm taking a look now, but if you wanted to provide a kind of a quick overview and update, I've been able to see them here. Yep.
Absolutely. The information regarding the ongoing criminal investigation, it's referenced in the report because that is something that I came across during my investigation and review of the body-worn camera. I did not dig further into that specifically because we didn't want to damage the integrity of that criminal investigation. With the administrative investigation, we were able to kind of work around that and not have to ask those questions because while that was part of the reason that they did request the K-9, the officer was also able to establish their own reasonable suspicion in the first place to make the stop. And through those conversations that they had had previously, were able to call the K-9. The policy here, CPD Directive 411, the K-9 unit section does state requesting personnel shall establish reasonable suspicion that a vehicle or package contains illegal narcotics prior to requesting the K-9 unit to respond. That information was established previously prior to their stop, and then they did conduct their stop based on reasonable suspicion for I believe it was the left turn signal that wasn't used coming out of the parking lot. So the stop was done with their own reasonable suspicion, the information regarding the ongoing criminal investigation, and then ensuing K-9 sniff was done with the previous information. The information was supplied through that ongoing criminal investigation. It does indicate that they did have reasonable suspicion to call the K-9 and to have them come. I know that part of your question was asking about how long that took. The reason that was omitted from the report, a specific number or specific timeline, is because in the policy it doesn't dictate what that timeline should look like because they can't say this should be within 20 minutes or 30 minutes. Each individual detention would be different, investigative detention. But the K-9 did arrive approximately 13 minutes after being requested. and the entirety of the stop took 36 minutes. The reason that the information was reported the way that it was in our report, in that the officer hadn't finished their ticket, was because typically past practice with the police department, and this was established to us through the legal updates training given by Chief Police Legal Advisor Furby, and information that they had previously established was that as long as this doesn't prolong the stop, then it's not going to be an issue with how long that stop should be. So with that officer continuing to write his ticket, finishing that, or not finishing that before the K-9 arrived, that had not prolonged the stop. Yes, ma'am.
So I'm on the same subcommittee. So what you're saying is that this complainant, this particular vehicle, was an issue of an investigation, of a prior criminal investigation, and this is the reason that the officers spoke to each other, and this is the reason for the K-9 search. So is that correct?
This vehicle was a part of that ongoing investigation from what
Yes,
we
and
gathered?
this is the reason why there was a stop made of this particular vehicle?
The reason that the stop was made by this officer was for not using a left turn signal.
Okay, but the vehicle was also, not only was that was the reason for the stop, but the vehicle was also being investigated for narcotics. Is that correct?
I don't have that information, ma'am.
Okay, then what was the reason for calling the K-9 to this particular vehicle?
The officer had obtained that information from a credible source, being somebody who was involved in that ongoing criminal investigation.
Okay, so there was an ongoing criminal investigation as it relates to this particular vehicle. Is that correct?
Yes, ma'am.
Okay, so this vehicle was signaled out, and it was followed, and then a traffic stop was. I'm just trying to understand here.
So, yeah, I mean, my understanding, it seems to be that because the vehicle did not use the left turn signal, that was the reasonable suspicion to pull over the vehicle. I mean, I would have specific questions about, did they know that this vehicle was a part of an ongoing criminal investigation prior to the vehicle making that, left turn signal question? And so, I mean, if they saw that, then could that count as well in terms of making a stop? So that's my understanding in terms of how the initial stop happened, was because it seems that reasonable suspicion was determined based on the fact that the vehicle did not use the left turn signal. Is that what I'm hearing correctly?
For the stop. Correct.
For the stop.
Correct.
And then from there, you guys didn't want to go into the full set of details because of an ongoing potential criminal investigation.
Correct.
Okay.
That information was provided to the officer on the body camera, limited information, after the stop was already initiated.
Okay. Pastor Tatum?
My question becomes, is this a common practice by CPD? Because it seems to me, one question that I would have is, did they run that plate before that individual made that, didn't make that left turn signal? That would be my first question. And based on them having a reason now to pull the vehicle over, knowing that this particular vehicle was part of an ongoing investigation, was that just something that they used to have probable cause, to call a K-9 dog in to check the vehicle out? Because I just want to know, is that a common practice by CPD?
We don't have, I'm sorry, go ahead.
I'm sorry. So we can't speak on the common practice of what CPD does in their different investigations, whether it's criminal, whether it's narcotic. What I can say is, in this case, looking at what the allegation is we look at whether or not the officer that conducted the stop, did he follow policy and procedure? And that's what we were able to establish, is that he had probable cause when he did the stop, and the procedure in which he called the canine was all followed by policy and procedure. He did receive some additional information. Now, how that additional information was received, we are able to see that and hear that on body cam. But there is a lot of times with CPD that there's information that officers are given based on whether or not we know whether there's maybe an Amber Alert, maybe there's a criminal they're looking for. So we don't know all of the different information that these officers get when they're out here doing patrol. But what we are able to say is when we listen to the body cam, what information we get. And so we do know that there was a conversation this officer had when this vehicle was pulled over, that he was provided some additional information that did assist him in establishing his probable cause for doing the, for calling the canine. And the canine came. The question was when the canine came, did they come in, what was the time frame? And so we're telling you, based on the policy and procedure, the time frame was within policy and procedure, and we're just referencing why. That's all in the report. So some of the additional questions that the board would have, we might not be able to provide answers, but those questions may not dictate whether or not the stop was valid or not, or whether it was in policy and procedure or not. And that's what we're stating, is that what we looked at is that the stop and the actions that the officer took was within CPD's policy and procedures.
Can someone remind us what the fourth allegation is, the one outstanding on this case, right? Can someone remind me what was the allegation?
The allegation is that the complaint alleged that the officer calling a canine was misconduct as he had no reason to call one to check her car.
Gotcha. Okay, thank you.
You know,
That was, you clarified it. I only have one final question. When you listened to the body camera, were you able to hear what the conversation was between the officers as to the ongoing investigation or not? The IG?
As to the nature of the investigation?
Yes.
No, ma'am. Just that there was an ongoing criminal investigation.
Okay.
So I do have a question related to just, how the IG's office operates in these types of instances. If there is an ongoing criminal investigation, at what level of information do you all need to know or could know in order to use that as, okay, that can help determine why the policy was followed here or not? Because otherwise, it seems like that could cover a lot as to why somebody might get pulled up. Well, there's an ongoing criminal investigation. So, is there a practice or at least a set of details that you all get in order to kind of make those determinations?
Absolutely. When we get that information, we would reach out to CPD, whatever department that is, to confirm whether or not there is an ongoing investigation, just to be able to validate that the information we received was accurate. And we did do that in this case.
Excellent, thank you. And the last just a kind of legal policy question, maybe we don't have to go into the specifics here, but my understanding, it's not enough that, or is it enough that there is an ongoing criminal investigation in order to pull a vehicle over in the first place, or is there? Because it seems like, again, the way it was listed here was that the initial stop occurred because a turn signal wasn't utilized. But if, let's say, I'm just trying to get some insight there, if there's any other way to pull a vehicle over, or if that was, because the concern that I have potentially is that they already knew that this vehicle in particular was involved in an ongoing criminal investigation, and the traffic violation was used as an opportunity to pull over this particular vehicle. And so did they need that extra piece or not? And that's just a general question that I have. Or maybe not general, maybe pretty specific, but.
Do you mind? Yeah, go ahead. The policy dictating arrest, search, and seizure, their arrest, search, and seizure manual, investigative detentions. Section 2 does talk about establishing reasonable suspicion and does say that an officer may use information supplied by another individual to establish that reasonable suspicion. So they are able to use information from another source. That policy does go into a little bit more specifics, if you wanted to read through that as well, about what, what is good information, what's valid, how they should corroborate that information. But they could use that information. I think that the officer, having established their own probable or reasonable suspicion to pull the vehicle over, I don't know, was that prior knowledge about the criminal investigation? I'm not sure. But that's not something that would have been within the scope of our investigation, and we didn't want to violate the collective bargaining agreement in going outside of the scope of our investigation. So we wanted to keep it narrowly focused to what this was.
Great, thank you.
Can offer 2 cents. I was a prosecutor for 23 years, so I have a few pieces of information about reasonable suspicion and probable cause. Officers can run plates. Whether they can stop a vehicle based on what they find depends, it's a fact specific. If it's a stolen vehicle, if someone's got a warrant out for their arrest and they can verify that the person who's actually operating the vehicle is the one who has the warrant out for their arrest. If there's an Amber Alert, if there's a missing person, things of that nature, they could stop the vehicle solely because of running the plate and that information. But the left turn signal would be reasonable suspicion to stop the vehicle, and then doing their due diligence, getting the person's driver's license, insurance, and running it. If something pops up inside their cruiser on their screen, indicating that that vehicle or that person may be involved in some type of current ongoing investigation, could then allow them, provide additional reasonable suspicion to bring out the canine.
Great. That's helpful. Yeah, thank you. Yeah, and I think this is really helpful. Obviously, understanding that these were the details kind of behind the scenes in terms of why everything wasn't presented on the report is where we had specific questions as to kind of how long, what was going on. But this is clear for me in terms of what that explanation is. So I appreciate that. I don't know if anybody else on our committee or anywhere else has further questions.
No, thank you very much for giving us that thorough response to last week's question. We appreciate it.
Thank you.
And so I'll go ahead with a motion to move ahead to accept the investigator's recommendation for case number 2022-0411. And that additional allegation there was allegation 4, and that was an allegation of the complainant alleged that the officer calling a canine was misconduct as he had no reason to call one to check her, and that allegation was exonerated. So we will move forward with that recommendation for our subcommittee.
Second.
Any other discussion? All right, all in favor, please say or raise your hands. Great, thank you. Motion passes.
Thank you.
All right, moving on to this month's case reviews. Because Pastor Nathan is not here, I will be giving our subcommittees summaries and recommendations. And again, we'll ask someone else to make the motions at the end of each report. Case number 2022-0445, filed November 2nd, 2022, submitted January 18th, 2023. Here, the complainant alleged misconduct after he made noise complaint calls to CPD. He alleged that his calls were ignored and that a CPD lieutenant was dismissive of his complaints. 5 CPD officers were alleged to have been involved. A review of EEC records, CAD reports, and body-worn cameras revealed that officers did respond to 2 separate noise complaint calls from the complainant. During the first response, officers advised college students who had set up speakers in a tent to turn down their music, which they did. But the officers had to return when they were called again for a second complaint. They found the same college student who they initially told to turn the music down, reminded the student that they were supposed to have turned the music down. Although the complainant originally believed that his calls were made on October 15th, records reflected that the calls were made and responded to on October 22nd and 29th. There's nothing in the investigation that would demonstrate that the officers did not respond accordingly. They did show up and they did ask the college students to turn down their music. The IG recommends the report be closed as unfounded, as nothing in the officer's behavior reflects a violation of CPD policies or procedures. In light of this, unless anyone has questions, I'd entertain a motion to accept the IG's recommendation of unfounded in case number 2022-0445.
So moved.
Second.
Thanks. All in favor, please raise your hand. Thank you. Motion passes. Next up is case number 2022-0451, which was filed November 3rd, 2022, submitted January 24th, 2023. Here, the complainant alleged that CPD officers sped through an active school zone when the school zone had flashing lights, requiring a 20 miles per hour. Specifically, the complainant alleged that officers were going 35 miles an hour, and school had just been dismissed. The IG's office requested and reviewed speed check data on the cruiser in question and found instances of the cruiser going above the speed limit around the time cited, but those instances were not found specifically within the school zone. Body-worn camera footage indicates that the officers in the cruiser were investigating a suspicious person and stolen vehicle during the time alleged of the alleged misconduct, but there was no audio conversations recorded regarding the school zone in particular. The school crossing guard was interviewed and did not see the cruiser in question during the time alleged, and there was very little foot traffic around the time that the speeding through the school zone was alleged. Therefore, although officers were in the area around the time of the allegation and were speeding outside of the zone, because it was incident to their investigation looking for a stolen vehicle, and then there was no evidence to support a finding that they were going 35 through the active school zone, the IG recommends closing the case with a finding of exonerated. Anybody have questions on that? Okay. In light of this, I would entertain a motion that we accept the IG's recommendation of exonerated in case number 2022-0451.
Second.
Any discussion? All in favor, please raise your hand. Thank you. The motion passes. Case number 2022-0459. This complainant alleged that officers laughed about her suicide attempt when they came to her home to assist her. A college student had sent what was perceived to be an email with suicidal ideations to a professor, and officers responded in light of that email. When they arrived at her home, officers spoke with someone outside the home, asking about the student's whereabouts and her well-being. Review of body-worn cameras and an interview with the officers reflected that the officers arrived, talked with the complainant about how she was doing, whether she was feeling depressed. At the end of the conversation, the complainant said that the officers were the nicest that she had ever met, at which point the officer started laughing, only in response to her comment that they were nice. Concerning the allegation of the complaint, the IG recommends a finding of unfounded. However, because one of the responding officers did not turn on his body cam during the incident, the IG has also recommended that the officer's failure to do so be forwarded to the chief of police for review and consideration of disciplinary action in accordance with CPD policies and procedures. So first, we'll have I'd entertain two separate motions. First is to accept the IG's recommendation of unfounded on the initial allegation in case number 2022-0459.
So moved.
Any discussion? Not specifically that the officers laughed at the situation. All right. All in favor, please raise your hands. Motion passes. Second, on the same case, 2022-0459, I would entertain a motion to allege an additional complaint, specifically that the officer failed to turn on their body-worn camera during the incident, and with a recommendation that the incident be forwarded to the chief of police and/or director of public safety for review and consideration of disciplinary action in accordance with CPD policies and procedures.
Do you have to, just quick point, do you have to put sustain there as an allegation?
Yes.
Okay.
To allege the additional complaint and sustain that complaint in light of the officer's failure. Any seconds?
Second.
Any discussion?
Yeah, on this, when it comes to these incidents, when the body-worn cameras aren't turned on, are there any situations in which there's also recommendation of discipline, or is it just recommendation of forwarding to the chief of police? Because I know there have been other cases and instances where this has occurred, and I know that sometimes there's a recommendation for discipline, and sometimes it's just a recommendation for forwarding it to the chief of police.
This one came with, which is why I repeated it, consideration of disciplinary action in accordance with CPD policies and procedures. So in my recollection, and Attorney Tobias can tell us if I'm wrong, but there is this graduated discipline steps that are available, that's what the chief of police collective bargaining would start with if
Right.
they decide to pursue
It
discipline.
looks like the IG was recommending forwarding to the chief for potential discipline, so yes, I think that was in the motion.
Yeah,
And
and the-
secondarily, yes, it's a progressive discipline model, so the chief, and it doesn't just get decided by the chief. There's a chain of command, and it goes
Yeah.
through steps, and there's a process to determine what, if any, discipline is appropriate.
No, that's helpful. And I guess the reason I was asking is just because as a board, some of the recommendations that we made that depart from the IG's office have been in cases to sometimes impose discipline or, recommend specific steps of discipline. So I was just wondering in this particular instance, why we're using this language versus other language.
Yep, I just used, and I've tried to use in the motions I've made directly from the language of the IG. Or in instances where we recommend training, but no one else, but that didn't come to us in the report, we might have recommended additional training. But that's usually when it's outside of what the report says. I don't know about other subcommittees.
Any thoughts from folks?
Well, I would think, that if we wanted to add something to that, in our recommendation to go to the police chief, shouldn't we not, or whoever the next level is, I think that we should be able to do that because I think we just did that in the last motion that we made. But I think that the investigator, is more abreast of what went on in the investigation than we are, unless we have some serious question about something. And I think that we should be able to, me personally, that we should be able to recommend that we forward it the same way, in the same language that the IG has done, unless we think that there's something else going on.
Yeah, no, I mean, I agree. I just think that, figuring out, there's just, at some point, obviously not for discussion now, but for moving forward, is standardizing a process by which we make our recommendations when and if they depart from the investigators' reports. Because I know that previously, at times when we make additional recommendations of discipline, it wasn't always in the language of forwarding it to the police chief to, for consideration of discipline. So I just would want to put out there that I hope that we can more standardize our process and our language so that it reflects what ultimately the chief of police and others would decide as it relates to discipline action.
Any other discussion on the motion? No? All in favor, please say aye or raise your hand. All right, thank you. That second motion passes. All right, next, our group had case number 2022-0477, filed November 14th, 2022, submitted February 2nd, 2023. Here, there were 4 allegations received by the IG's office following an incident of arrest of the complainant. First, an allegation that officers did not give the complainant their badge number or names when asked. Second, that officers would not respond when the complainant was asking why he was being arrested. Third, that when the complainant responded with his name, which had a specific ethnic background, the officer said, "Oh, you're one of those." And fourth, that officers pushed him to the ground, arrested him, and threw him in the back of a squad car so that he began having back pain. Investigators from the IG's office conducted interviews, reviewed body-worn camera footage, and reports indicating that the complainant was intoxicated at the time of the incidents and had been told by an employee of a bar and grill to stop playing with straws. The bartender removed the straws from the complainant's reach. The complainant got combative and slapped the bartender's hand away, at which point law enforcement was called. When officers showed up to remove him from the property, the complainant was not positively responding, appeared to be intoxicated. Body-worn camera footage reflected that officers provided the complainant with their names and badge numbers multiple times throughout the incident, and at no time did any of the officers say, "Oh, you're one of those," to the complainant. Officers were able to get the complainant cuffed and into a cruiser without much incident, and it did not appear that he was thrown into the back of the squad car. Accordingly, the IG recommends that the investigations and all 4 allegations be closed with a finding of unfounded. Our subcommittee took no issue with that, agreed. And so I'd entertain a motion to accept the recommendation of unfounded in case number 2022-0477.
Hold on just a second, because this was the one where we had the issue with the body-worn
numbers.
cameras
Yeah. Yeah, it looks
on
like,
special
Oh,
duty.
on special duty. Gotcha, okay. Sorry, pausing for this one. So this was, and my apologies,
also the numbers are a little off.
those are the same numbers that you have.
0477.
Right?
Yeah, this
Yeah.
is the right one.
Is this the one? Oh, is there one of those?
No, this is a different,
This is the same one.
let me see the allegation. Yeah, which numbers are off?
I see it says 40459 at the top.
Oh, I think this is one where, apologies briefly. So this has happened before. We know that sometimes the number that's generated in the case processing system, thank you for the word, doesn't always equate to the end resulting number. So I think what we have is 0477 is also 0459.
Yeah.
Does that look right?
I got those two.
Is that
Okay,
Yeah,
okay.
yeah.
So this is an instance in which our recommendation on the allegation itself is not in disagreement with the IG's office, but where we do have an additional recommendation that we'd like to put forward. And so I'll separate it into 2 motions. I'll give a little background to what our issue was. This is the second time that we've seen a case where special duty officers do not have to wear body-worn cameras. And so part of our issue has become, even though it didn't happen in these incidents, what happens where there is an excessive use of force or there is a police-involved shooting, and we have officers who don't have to wear body-worn cameras? Is that a policy that we'd like to have revisited? So that's how I'll be setting this motion up, as 2 separate motions. One is to accept the recommendation that's already been given, but then 2 is to make a recommendation on reviewing the policy related to body-worn cameras and special duty ops. Does that make sense?
Yes. So
Okay.
moved.
Yep.
Madam Chair,
Yes.
I remember one case that we had as well that dealt with this. I think it was an officer, an off-duty detective that was in the Kroger store, I believe it was. And I guess policy is that detectives don't have to wear body-worn cameras. And I took exception to that because had he had a body-worn camera on, there would have been more clarity in this case as to exactly, in that case, as to exactly what happened there. But because there wasn't, the other cameras and stuff were very grainy, and you could not see everything that transpired in that interaction. So, yeah, I think this is becoming something that we really need to have reviewed.
So what I'll do is I will first entertain a motion that on the allegation that was currently written or written in the original complaint, to accept the IG's recommendation of unfounded for, and I'll put on this record, 2022-0459, because I'm not sure if it's 459 or 477, which one was the? Okay, thank you. 477 is the official case report.
So moved.
Second.
Thank you. Anyone have any further discussion? All right, all in favor, please raise your hands. All right, for the next one, same case, 2022-0477, I would entertain a motion that we make a recommendation to the Chief of Police and/or Director of Public Safety about reviewing the policies pertaining to body-worn cameras and officers that are currently accepted from having to wear those.
So moved.
Second.
Any other discussion?
Wanted to get a sense of reviewing versus changing or recommending a change. I mean, what is recommending a review of the policies? I mean, you can just review the policies.
Well, so I think before the change has to be made, there has to be a review to see exactly. But here on our sheet that we did put a review and change of policy.
Yeah. And so, yeah, so specifically, I know we can recommend something that they can decide whether or not to move forward on, but I don't know, in terms of using specific language, it seems like the board itself feels strongly about actually recommending a change of policy. But, I don't know, Pastor Tatum.
Madam Chair, I'd like to make a motion that we amend that motion to stipulate those two things, review and change, and make a motion to that effect, or amend the motion that's already on the floor.
Yep, I'll accept the amendment. All in favor, please raise your hands. All right, thank you, motion passes. And just so it's reflected, it is on the sheet that was turned in, so that's my fault for missing that language. All right. Next case is 2022-0484, filed November 14th, submitted January 30th. In this case, the complainant alleged misconduct on behalf of CPD concerning the stopping of the complainant's car for a window tint violation. Complainant alleged that he was followed for 20 to 30 blocks before he was finally pulled over. The allegation was that his window tints, the complainant alleges that his window tints were not in violation. However, he was basing that on his understanding of what the law was prior to a change that was made in July of 2021. And so accordingly, the IG investigated and found that his window tints actually were in violation of the revised 2021 statute. And therefore, there was no issue with the officer pulling over and enforcing the window tint statute. Accordingly, the IG recommended that this complaint be closed with a finding of exonerated because he did pull over, the officer did pull over the complainant, but because of the change in status of the law, the complainant was just unaware of what the law was. In light of that, I would entertain a motion that the complaint in case number 2022-0484 be closed as exonerated.
Hold on, this one, there was some inconsistency.
I talked to her about it.
Oh,
I reached
okay.
out and asked her about what
Oh,
it
you
was.
did?
Mhm, I
Okay,
did.
cool. Got it. Well then,
Well, I don't know,
Some-
I don't know what that is. What is it seems like something was listed as exonerated versus unfounded.
So unfounded is, and I did speak with the IG just to get some clarity. Unfounded is when the action alleged did not happen, and therefore it's unfounded because there's nothing to substantiate that even the act took place. Exonerated, it was where the complaint that was alleged, the thing took place, but it doesn't necessarily rise to the level of a violation of policy or procedure. And so in this case, the IG, in finding exonerated, believed that the thing that was complained about took place, but that in and of itself was not a violation of the policy or procedure.
Was that 20 or 30 block allegation referenced in there? Was that the case or not?
So his specific complaint was that he did not believe his window tint violated the issue. He mentioned that there was, that he had been followed for that length of time, but it did not appear that anything that was done violated any of CPD's policy.
So, I mean, I do have a question, specifically as it relates to the complainant's statement that he was followed for 20 to 30 blocks. I mean, is that the standard practice in this instance, or I'm just trying to get a sense of
Well, I
that?
don't think it was part of the allegation.
Well, and I,
The window tint was the deal.
yes, the window tint was the deal, and typically, we would like to encourage, if there's other violations, that those are brought up, but I think it's a decent question. I'm not sure how long you are, I don't know that there's a limit. Mr. Tobias, you can tell me if there is, but I don't think there's a limit on how long that tailing can happen before a pull.
There's not, it's just
yeah.
case by case. I mean, it just depends time of day, neighborhood, can they pull the person over safely? Maybe they're running something on their cruiser computer before they decide to pull the person over. There could be a whole variety of reasons why. They could be finishing a sandwich. I mean,
Got it, thank you.
Yeah.
I guess my only thing was when we initially got this case, there were two different findings. One was unfounded, one was exonerated. So and I'm glad you got some clarification on that. So just checking for IG and her team, if y'all could be a little consistent with these cases, so that way we have that stuff up front.
Well, and I think, and you can correct me if I'm wrong, IG Hendricks, but when an investigator pulls out the report, if you think that the proper closure should be something different than what the IG found, my guess is that that's what you put in there. Is that correct on this case or no?
That is. So what I will say is I did provide a little handout, and I can actually go through it just to do a little bit more clarification. So one of the things when we get the reports is I do review everything. And so what I will say, sometimes doing the unfounded and the exonerated, just as the board is discussing, sometimes we have those discussions ourselves.
Okay.
And what we will tell you is when it comes to the exonerated, and if you look at the form, it says the investigation found evidence that the allegation incident occurred, it happened, but that it was supported by policy and procedure. So generally, when we look at what the allegation is, we look at that and it's investigated. So if, for example, someone makes an allegation that there was a use of force, we try to get clarity. What do you mean use of force? That could be someone stating that they were taken to the ground, maybe punched. So when we look at that, we may look at and say that that did not occur as to what they're alleging. And so that would be unfounded because it did not occur. But if someone makes an allegation to say, which we do get cases that say, it was excessive use of force, they took me to the ground. So what we would do in a case like that is our finding would be if that in fact happened, that would not necessarily be supported by an allegation of excessive use of force, but it would be that the officer did do that, but he did that within policy and procedure. So he would be exonerated, because what we want to make it clear is that we're not exonerating an allegation of excessive use of force. We're exonerating the fact that the officer's actions was in support of policy and procedure. And so with unfounded, again, that's when we get those allegations that the person was taken to the ground, they might have been hit, they might have been dragged, and we look at that and we say the allegation in itself, what we looked at, did not occur. So that's when we make it unfounded. But there are times that we look at stuff and, again, it's kind of not clear cut. And so in cases like that, my investigator may write that, and when I look at it and I look at the policy and I look at the documents, I may change the finding, and it's my catch to make sure that it's changed throughout the report, and that may have been a case where it was not changed throughout the report. But what I will tell you, and that's what I shared with Vice Chair Burns, is that as a team, we talk. There's nothing that if there's a change or something in a report, we talk with the investigator, we talk as a team so that they understand, so that we are consistent in reporting what our findings are in the investigations.
Okay. So we'll go with your final recommendation moving forward then, please. Got it. Okay.
Thank you.
So just so we can go back and have a clear record, we have a motion on the floor about complaint 2022-0484. Do we have a second? Okay. And all in favor, please raise your hand. All right, motion passes. Thank you. Next is case number 2022-0486, filed November 15th, submitted December 30th. Here, the complainant alleged misconduct by CPD following a domestic standby for clothing run. The complainant had police escorts while she retrieved clothing and medication from the home she previously shared with her domestic partner. Former partner sat on the couch while she gathered her things. She was taking a while to gather her things, and officers repeatedly asked her to not delay, but to get her necessities. The investigation reflected that their tones were not aggressive, even though they might have been raised. Officers had to remind the complainant that they did not have the capacity to wait for her to move all her belongings out of the home, but that she had to grab her essentials and a change of clothes. Following the investigation, the IG determined that the actions of CPD were within policy and procedures and that there were no violations. Accordingly, the IG recommended a finding of exonerated. Our subcommittee did not have or take issue with the findings themselves. I'd entertain a motion that complaint number 2022-0486 be closed as exonerated.
Second.
All right, so any discussion?
Yeah, so this is kind of just the unfounded exonerated point we just talked about. I'm confused here. What is exonerated versus when it's kind of a subjective standard as it relates to whether or not somebody behaved inappropriately and condescending versus an unfounded of that not occurring? That was a question that I had.
So hopefully I'm answering your question. So the allegation in this complaint was that the complainant alleged that the officer behaved inappropriately and condescending towards her by telling her to hurry up. And so what this investigator did is, and this is kind of a lengthy report, is they talked about what they observed on the body cam. So they were providing the complainant time to remove their items. And while they, on more than one occasion, consistently asked the person to, get their items and continue on, they were only there to supposed to be there a certain length of time. The complainant wasn't listening. So when the officer asked them to hurry up, it wasn't being rude. They were just letting them know that they were only there for a certain period of time and asking the complainant to please, proceed in getting your items. So again, that was the reason why we said it was exonerated, because the officer did say that, but it was not a violation of policy and procedure. He wasn't being rude. He was just letting the complainant know that, their time had kind of.
Got it. Thank you.
Thanks.
It's helpful.
Any other questions or discussion? Yes, Reverend
Yeah,
Tatum.
just very briefly, and this was also backed up by the video that the investigator was able to look at. Okay.
Right.
Great. Thank you.
All right, we've got a first and a second. All in favor, please raise your hand. All right, thank you, motion passes. And this is the last one from Team 1, case number 2022-0488, filed November 15th, submitted January 26th. Here is, the complainant was issued a citation for being parked in a accessible parking spot, even though she did not have the pass to be able to utilize the spot. Specifically, her allegation was that she was ticketed while other more fair-skinned individuals who were also parked in the accessible spots were able to move their vehicles prior to officers stopping and addressing them, so no one else was ticketed. The body-worn camera footage revealed the complainant was sitting in the spot while waiting to pick up an employee from inside a government building. She was upset that others who were in the area were also not ticketed and let the officer know about that. She had wanted to just get a warning or have a chance to leave, which she did not get before officers approached and ticketed her. The IG determined that there was no evidence to support her allegation that they specifically targeted her to prosecute instead of any of the other individuals who were parked. She just happened to be the first car that they came to, and when they came to her, everyone else left. Accordingly, the IG determined that there was no evidence of violation of policy or procedure. In light of that, they recommended that the case be closed as unfounded. I would entertain a motion that the complaint in case number 2022-0488 be closed as unfounded as well. So we've got a motion and a great second. Any discussion or questions?
Yeah, I mean, I've got a couple questions here just for discussion. So it seems that in this particular case, the investigator reviewed to see, and it just seemed like that was the first person that they made that for. This is a particular case that I think puts on the floor potentially for the potential for documenting and tracking complainant voluntarily submitting demographic information. So this is something to think about, because in order for us to kind of collect and track databases, especially allegations of potential bias, it would be helpful to know, for instance, if there is a pattern or practice of issuing citations that, sustain this particular allegation. So that's one thing that in this instance, it seems like that wasn't the case, but if we had broader context as to whether or not this has happened before with this particular officer or there is a pattern of this, it would be helpful to know. or even tracking the types of complaints that make these specific allegations of bias based on race. So that is just one thing I want to put on the floor just for discussion for us to think about.
Without knowing the other individuals parked there, how could you make that determination? Because all we know is, the complainant, we don't have any other way to investigate who else was parked in that spot. It's my only concern.
I think her allegation was fair-skinned, but she did not specifically state that every other person was a different race. And so I feel like I don't think we can't. Inspector General, correct me if I'm wrong, there is a way to pull complaints that are based on, let's say, a particular officer and see within the case management system, see how many complaints have come in about a specific officer. Is that correct?
Yes, our case management system will allow us to search to see what complaints came in by officers. We're also, based on the allegation, whether the allegation involved bias or I think there's profiling, so we can actually pull and see if we have several allegations like that involving that officer, or even if we just wanted to search by bias or profiling, how many complaints we've received regarding that. But again, it would, go based on the investigation that we did and what our findings are. And in this case, with that allegation, again, they were parked illegally, and my investigator actually went to the site to walk over to see if there were other cameras from the court system to see if we were able to possibly maybe identify what some of the other drivers were, and we just were not able to do that.
Excellent, thank you. No, it's helpful, and I think, and I agree with the recommendation here, but I do think in order for us to see the types of patterns, if there are any, right, it would be helpful to track or document this information. And so both for the IG's office, but even for a board, for us to think about, if there are patterns that we're starting to see, how we would then, move forward when we review these types of cases. But that's all the discussion points that I had. Thank you.
If there was a pattern established, would we have the ability to go back and look at each individual case to see that person's ethnicity?
So what we would have the ability to do, and that would be something that my office would be looking at, is if we got an allegation, let's say, involving a certain officer, we would be able to look and see what kind of complaints we've received, and we would be able to pull the report to see if there was, what the information was in the report. So we would definitely be able to look at that, but that would just be based on the report that was done. So what I will also say is, we have gotten complaints that might be something about profiling or bias, in which we've tried to do research and we're not able to get any additional information. So it could possibly list the officer's name, but if we're not able to get information to conduct an investigation, then that would have been closed. But it still will list that officer's name if, in fact, the complaint we got was able to identify who that officer was.
Thank you.
Thank you. So we have a motion and a second on case number 2022-0488, that it be closed as unfounded. All in favor, can you please raise your hands? Thank you, the motion carries. So that's all the cases for Team 1. At this time, let's take a break and come back at 3:20. So about 13 minutes, take a break, and we'll reconvene for the next two teams. On the record, to continue with case reviews, I'm going to turn it over to Board Member Strickland for Team 2's case report outs.
All right, thank you so much. So our team did a subcommittee review. The first cases that we will read here is case number 0496. This particular complaint was classified as misconduct, but in this particular complaint, there was an administrative closure in this instance. I'm trying to pull up this. You have that? Thank you. In this particular instance, there was administrative closure because the Department of Inspector General could not identify any CPD officers involved in the accident matching the description given by the complainant. So our subcommittee didn't have any issues with this particular complaint. We agree with the IG's findings and recommendations of administrative closure. I will say, before we kind of go ahead and make the motion on this, I don't know how our board wants to handle cases of administrative closure, just in terms of for efficiency purposes. Thinking about a more fast-track review process, just because I know the way that we divide up, have been currently dividing up cases. When you get an administrative closure case, there's not much there, for us to look at because it's not a full investigation. So we should think about how we fast-track administrative closure cases.
I agree.
Yep. So, but I will make a motion nonetheless on case number 0496, motion to agree with the IG's finding of administrative closure.
All in favor, please
sorry,
raise your
yes.
hand. All right, motion passes. Thank you.
Next, we have case number 0502. And this is a case where the complainant alleges that she called the police to her residence to make a report against those who assaulted her, and the officers filed no charges, made no reports, did not interview witnesses, and did not look at the video of the assault. The complainant stated that the officers did not do their job properly. The Columbus Department of Inspector General reviewed body-worn camera footage, computer-aided dispatch reports, 9/11 communications audio recordings, and the case summary report from the officer. The investigation found no Columbus Division of Police policies and procedures violations by the officers during this incident. Therefore, it is recommended that allegations 1, that the officer did not file charges, be closed exonerated. Also, it is recommended that allegations 2, the officers did not write a report, and 3, the officers did not speak with witnesses, and 4, the officers would not look at video footage, be closed with a finding of unfounded. Our team did not have any additional concerns or issues with this particular investigation. I don't know if there are any other notes. And so we would move ahead with the recommendation of, we agree with the IG's recommendation for case number 0502. We'd make a motion for allegation 1, the officers did not file charges, be closed exonerated. And then allegations 2, the officers did not write a report. And 3, the officers did not speak with witnesses. And 4, the officers would not look at video footage, be closed unfounded.
Second.
It's been moved and seconded. Any discussion? All in favor, please raise your hands. All right, motion passes. Thank you.
Next, we have, sorry, just want to make sure. Case number 0506. The complainant alleged that he called 911 because a male was trying to kick in the door of his residence. After a lengthy delay, the officers arrived on scene, but the suspect had left. The complainant directed the officers to the park, stating that the suspect fled in that direction. The complainant stated that the officers made the decision that no crime had been committed. The complainant stated that their conduct was not professional and possibly not legal. The Columbus Department of Inspector General reviewed computer-aided dispatch records, revealing that 2 officers were dispatched to this call. Also reviewed were audio recordings from 3 calls to 911, body-worn camera footage, a CPD report, and cruiser GPS data. Based on the evidence that was reviewed by the Columbus Department of Inspector General, it concluded that the officer's actions were within policy and procedures. Therefore, the Department of Inspector General recommends a finding of, quote, unfounded for all three allegations. And I'm just going to read the specific allegations here. Allegation 1 was that the complainant alleged that officers took too long to respond to someone breaking into his home. In allegation 2, the complainant alleged that he told the officers which direction the suspect ran, but the officers decided that no crime had occurred. In allegation 3, the complainant alleged that the officers' conduct was unprofessional and may have been illegal. For all three of those allegations, the IG's office recommends a finding of unfounded. The subcommittee did not have any concerns or additional questions related to this particular case, and so our subcommittee would move to recommend a finding in agreement with the IG's office of a finding of unfounded for all three allegations. So I'd like to make a motion for case number 0506 of a finding of unfounded for all three allegations.
It's been first and seconded. Are there any questions or discussion? All in favor, please raise your hands. Motion passes. Thank you.
Next, we have case number 0508. This was classified as misconduct, and this particular case was withdrawn. Similar to an allegation, or similar to the finding of administrative closure, this case was withdrawn because the complainant withdrew their complaint. And so nothing further to add in that particular situation. So we would recommend, I would make a motion to move ahead with case number 0508 to sustain the finding of the IG's office of withdrawn.
Second.
All right, any discussion?
Yes. Another type of case that we should consider as a board, in the future, whether or not, that should come to this level.
Completely agree. And so both with administrative closure cases, withdrawn cases, and maybe, we can talk about it working with the IG's office, but, however you all track those cases, and maybe there's another track in which either our subcommittee receives it or something so that we can fast track those and maybe combine them in motions that we make in the future. That would be my recommendation.
Chair, so I just wanted to add, even with withdrawal and administrative closures, what you will find is sometimes we get allegations. The allegation may not have enough information, which is why we do go out there and still try to contact the complainant to get additional information. What we will tell you is even if someone comes back and say they want to do an administrative closure or they want to do a withdrawal, if we have enough information, we do still try to look at what we have, but there are times that the information we have is just not enough, which is why we will still do an administrative close or withdrawal. So letting you know that, so if you still want to at times just review it to be able to see why we closed it, that's fine. If you just want to, forward it and not do that, that is absolutely fine. Just want you to understand in these two cases, you'll see there was an allegation made. They just didn't give us enough information to proceed, which is why we ended up closing it or, going with their withdrawal.
That's helpful. Thank you. Yeah, I think if we, depending on how we set this up, those, obviously we can have an initial review of the cases that are withdrawn or administrative closure, but it doesn't necessarily have to go into the pile of the cases that subcommittee reviews so that we have, a full set of cases that we can fully review. Thank you for that information.
Briefly, and Mr. Tobias, if you can tell us if we're wrong, I know that we have to move separately on each individual case, but is there any limitation, because we were the ones who set up the subcommittee structure of, and what I'm thinking is potentially having a separate spot in meetings where we have that batch of cases, that the board just hears the case numbers, hears administrative closure or withdrawn, and we can all individually vote without them going to
Also, the
subcommittees.
concern, probably not.
Okay.
The concern that I hear from the IG is that even if there's an administrative closure or withdrawn, there's still details in the report. And if you look at it as a subcommittee and determine that maybe the IG overlooked something, or there's something that catches your eye, or you want something further explored with an officer, you can refer that back to the IG, even though the complainant may have asked for it to be withdrawn, or they weren't able to get cooperation from the complainant for further investigation of one particular complaint. They may find that body-worn camera wasn't used or something, so you could refer it back. So that may be a situation. Or the opposite would be, it's withdrawn or closed in one respect, but then they found some other violation of policy, which then they're asking you to act on. So in those situations, those probably should stay with the committees for review.
Okay, thank you for that.
Yeah.
I appreciate it.
It's helpful. Yeah, yeah, we can determine kind of best way to do that moving forward. That's helpful. The last one was 508. Was that the one that I just, or 509?
Yeah.
Okay. Next up. Do we still have a motion on the floor? No, I think we carried that one.
We
right?
carried it.
Yeah.
Thank you for that. I appreciate the next up, we have 2022-0509. This case was a complaint. It was classified as use of force. The finding here is administrative closure. And that particular justification of what that means is complainant was closed for reasons such as non-involved CPD officer, a duplicate complaint, or insufficient information to investigate the complaint, et cetera. We agree with the finding of administrative closure, so I'd like to make a motion on case number 2022-0509 of administrative closure.
It's been first and second. Any discussion? All in favor, please raise your hands. All right, motion carries.
Next, we have case number 0527. And the summary is that on November 28th, 2022, the complainant filed a complaint with the City of Columbus Department of Inspector General alleging misconduct by unknown CPD officers. The complainant alleged that the officers towed/impounded his vehicle despite him being gone for a reasonable amount of time and arriving back before the tow truck arrived. In addition, the complainant alleged that the officers were extremely rude after a review of the body-worn camera footage and CPD policies and procedures, it is recommended that the allegations against the two officers involved in the incident be closed with a finding of exonerated, as their actions and conduct did not violate CPD policies, procedures, and/or law, according to the IGs. Our subcommittee requests further discussion on this particular case. Because there were specific allegations. So I just want to specifically name the specific allegations. So allegation 1 is that the complainant alleged that two officers towed and impounded his vehicle despite him returning back to his vehicle within a reasonable amount of time and prior to the tow truck arriving. And then there's allegation 2, which is that the complainant alleged that two officers were extremely rude, hostile, and threatening by stating that they did not believe him and by exaggerating the time. So there's a couple things here. So that kind of initial summary that I read was the summary that was provided. But to dig a little deeper into this particular case, somebody alleged that they had ran out of gas and they went to the gas station to get gas, and so they left their vehicle on the side of the road. And as they left that vehicle on the side of the road and returned, there was the officers were there to tow and impound the vehicle. And so we had some further discussion and concerns related to this case. One is the officers made several statements suggesting that the complainant was intoxicated and lying. So we had just questions generally about how did the officers make this determination, and wondering whether the officers' actions and comments toward the complainant rise to a level of a policy violation. And we also just a general question, what is the practice of when to impound/tow a vehicle when the occupant arrives on the scene at the same time as the tow truck? It is indicated that it is within policy and at the officer's discretion to impound or tow a vehicle when a contracted wrecker comes at the time the complainant arrives on scene. But in this particular instance, that combined with the statements made by officers that they believe that the complainant was intoxicated and lying about how long they had been away from the vehicle, we had some concerns about that particular instance. And I don't know, Mary or Pastor Tatum, if you have additional questions or comments.
I do. The officer in this case indicated that that he thought the individual was intoxicated. Well, if you had the chance to see the body cam, what were the indications that this individual was intoxicated? He said that he didn't believe that this individual went off to fill a gas tank, that he may have gone off to some bar. Well, was there any indication that was the gas tank empty? Or also, maybe we kind of wanted some meat on this case. And the officer said, you should have been back here in 10 minutes. Well, where was the car located? Where was it stranded? And where was the gas station in relation to that car where it had been stranded? There were these questions needed to be interviewed so that we could kind of make sense out of this scenario. And also, was the body cam enough in this situation, or should the officer have been interviewed? So just need a little info. You probably have it.
So one of the things that we have asked the board is that we really would love to provide the board with any answers to any of the questions that you have with the reports. Having those questions to us in advance so that we can provide a written explanation would be great, just as you can see with the report involving 411. We were able to answer the questions. We also provided a written document which, provided clarity for, Board Member Strickland. So we really encourage the board, when you have questions, please reach out to us. I mean, this is what we want to make sure that we do. But in reference to your question, at page 4 of the report, it talks about the policy. It also talks about what they were able to review with the body cam.
So yeah, thank you for that, and that's helpful to know, and I guess we still had just generally some outstanding questions, and some of this is both for the investigators, but then also just generally as a board, and we can think about the practice of when we have further discussion about the particular case and what it is that we discuss with the Inspector General's office as well as with the board. In this instance, the allegation itself was that the complainant alleged that 2 officers towed and impounded his vehicle despite him returning back to his vehicle within a reasonable amount of time and prior to the tow truck arriving. Then there was a separate allegation that alleged that the 2 officers were extremely rude, hostile, and threatening by stating that they did not believe him and by exaggerating the time. And those allegations were reviewed separately, and the determination was that, 1, the officers had discretion of whether or not to tow or impound the vehicle, and then 2, it was not seen as the officers being extremely rude, hostile, or threatening. But what was not necessarily covered is that the officers were saying that the complainant was intoxicated and lying, and he had mentioned that the officers had mentioned that to one another as well as to the tow truck driver. And so I guess that's kind of the question that we have is those comments and allegations by the officers could have potentially served as, I mean, it seemed like that helped to serve as their basis for the reason of towing the vehicle. So that was one of the concerns that we had, which was, do those actions and comments toward the complainant rise to a level of a policy violation?
So the reason the vehicle was towed was basically because the vehicle was left unattended. And the body cam talks about the fact that the officers were standing by the vehicle and they had ordered the tow, and the owner was nowhere to be found. And they had been there for a while. During the body cam, they were able to see the owner when the tow truck arrived, decided to come out of where he was. I don't remember if he was across the street. When he saw the tow truck come up, that's when he came out and walked across. So that's what the officers are stating.
So, yeah, and so I see that, and I understand that and see that piece. The question that I was having was specifically related to the officer's comments that the complainant was intoxicated and lying. There's nothing in the report that either verifies that or corroborates, those statements made by the officers. And so the question that we were having as a subcommittee is whether or not the officer's statements about, this complainant is lying and he's intoxicated, whether or not that rises to a policy violation.
So just going with what you're saying, because I would have to look specifically more in the report, I would think that an officer that is at a scene and sees a person that is intoxicated we would be having a different conversation if they allowed that person that was intoxicated to drive a vehicle away. So if the officers are having a conversation among each other, which would be their reasoning for continuing on to have because they have discretion versus whether or not to tow a vehicle. But if the person came up and they assumed, or for whatever, I shouldn't say assume, but their conversation was that the person appeared intoxicated, then the officer's not going to want to allow that person to drive that vehicle because it could be a liability and it would be dangerous. And that may have been the conversation between the two officers that they had that as to why they may have told the tow truck driver to proceed on with. And I believe the conversation that the officers were having was the fact that because the tow truck appeared, this is the reason why the owner decided to walk up, because he didn't want the vehicle towed. The owner did not come when the officers arrived because he might have been intoxicated and felt that if he walked over there, the same thing would happen.
Yeah, and that's helpful to know. I think that the general question that I have is related to if an officer says that I think you're lying and I think you're intoxicated. I mean, can anybody say that? Or
So regardless of whether or not his assessment is correct,
Yeah.
he still has the authority to impound the car, so that can still go, regardless of if he's correct in whether or not the guy is lying or the guy is intoxicated. Even if he was totally wrong, the impounding of the vehicle is a go. I mean, it can be.
Yeah.
The other thing, I don't know if a couple things. You mentioned first that he appeared before the tow truck. Maybe that was his allegation. Or he appeared at the same time of the tow truck. So I heard those two. And there was something else, and it'll come back to me.
But no, you're.
Oh, did he have a gas can with him, with gas? Or did he mention, officers, I got the gas can in my hand?
And the thing is, I think even, and I would just say, I think even if that were the case, it seems that, I mean, even if you had the gas can in your hand or whatever, and you said, I just got the gas, like, the officer had discretion to tow the vehicle regardless. So that is within policy, right? So I understand that piece, and I think there's a broader question about when discretion is used or not, if somebody actually is pulled over or left their vehicle on the side of the road. The concern I have is as it relates to just the allegation that somebody's intoxicated and lying, and so that's why, and then going ahead just to tow somebody's vehicle, the complainant says that, these were the allegations. He's like, I thought the officers were being rude. And specifically, so I get more on the specifics here, when it related to allegation 2, it was that the officers were extremely rude, hostile, and threatening. In the investigator's report, it makes clear that the officer's action did not rise to the level of being extremely rude, hostile, and threatening. And so the question that I have is, as it relates to these other specific, potential allegations as to whether it's misconduct, if you're saying somebody's lying and is intoxicated, like, I don't know, and then you tow their vehicle.
How do you make that assessment?
Yeah.
How do we make that assessment? Did he do a field sobriety test? How did he make the assessment? Did he smell alcohol on his breath? Is that mentioned in the report? Those are the kind of things that I was concerned about, because to just say that someone is intoxicated without giving adding any type of validity to that, to me, that's not cool at all.
Exactly, and I'm with you. However, and it depends on how it was said, the delivery. So the complainant is saying that he said intoxicated. Did the video camera say, the body worn camera? Did he say that, or did he say?
That's what I'm trying to
Exactly.
get to.
He might have said, I think you might have had too much to drink.
Okay.
He could have said a couple different things, but the guy interpreted and said it as intoxicated. But we don't know
We
that.
don't know that.
And I'm saying regardless, even if we don't know, because I can say, I think you're intoxicated, and I think you're being less than truthful. There's not anything wrong with that, and I can still tow the vehicle.
Okay.
I'm not saying it's the nicest thing in the
Yeah.
world, but
Okay.
Well, I'm not even bringing the toe into question here. I'm just talking about the allegation.
the allegation from the officers saying he
No,
thinks he's
that he's
intoxicated.
intoxicated.
Yeah, he can do that. I can say that. I can say, I think you're intoxicated.
And there was no, just for clarity, there's no prosecution, like he wasn't arrested or anything
No,
for
but I
public
feel-
intoxication or, because that's what I'm wondering. Was he issued a citation for intoxication? Because if,
No, not without,
Because the problem that I have with this is this. The man could have been taking medication, and he could have been a little bit out of it.
okay.
But he's not intoxicated.
Right. And I'm with you. I agree with you. What I'm saying is let's say that he was on medication and I was wrong. What do we want?
Yeah, so, and so so it
I
seems.
want an officer to be able to not make those kinds of statements without having some type of validity to prove that.
I'll
But
tell
it's
you what, I would like for the officer to be interviewed to answer for this stop, to say, what about was there any proof that this man really went to get gas?
Well, and so here's the thing, though, and
You
I
know?
think the challenge is that it doesn't necessarily, he doesn't need proof.
right,
Well,
right.
that's
because he has
true.
discretion. So-
I think
so
at the end of the
it's-
day, regardless of whether he was right or wrong, he still had authority
Yeah.
to tow.
And so, and then I think the specific question, I don't know if Attorney Tobias, if you have the specifics around whether or not those statements can rise to a level of policy violation. I'm assuming it's obviously based on a specific set of factors, but I just had that.
Not really.
Okay.
I mean, it's clearly within the board's discretion in terms of how deep into the weeds you want to get on any particular investigation, what you're looking for, what you're not looking for, how critical you want to analyze a fact pattern. But a good starting point, as you probably already know, is, look at the allegations first. The tow, that was looked into. The officer can exercise discretion. You're going to, I don't know if it was unfounded or exonerated, but, and then the other issue is rude and hostile. Is an officer offering an opinion that they believe that this person they're interacting with is intoxicated or has been drinking? Is that being rude or hostile? Is that in violation of the policy? Again, I agree with Board Member McIntosh in the sense that officers are drawing conclusions and making statements based on what they're seeing and observing as they're investigating. Sometimes those things prove to be wrong or untrue, but if they're doing it in good faith and basing it on the totality of the circumstances as they're experiencing it, then that's sufficient.
It's helpful.
I have a question. So why wasn't the officers interviewed?
officers weren't interviewed in this case based on what the allegation was. And I think the allegation was, if we go back, was involving I'll go back through just to say, the first allegation was the complainant alleged the officers towed and impounded his vehicle despite him returning to the vehicle with a reasonable amount of time. Now, that's his allegation. We already established the fact that the officers arrived. There was body cam footage. They sat out there that whole time. They waited for the tow to arrive. And when the tow arrived is when the complainant decided to walk over. The second allegation was the complainant alleged that the officers were extremely rude, hostile, and threatening, and stating that they did not believe him by the time. So what we're saying, even with that, is the body cam did not show that the officers were rude or hostile. I think the other thing, and I hear the discussion that's going on, and that's a summary of what is written in the report, is that the officers had a discussion, and the officers can have a discussion. Part of being out on the street and making decision is talking to your partner. So they had observed this person that walked over here, and based on their observation, this is what they concluded was happening. The other thing is we have to rely on the fact that these officers, first of all, let me just say, the discussion would not change whether or not their actions violated policy or procedure. So what we would look at is, because of their experience, this is something they do on a regular basis. So they're going to be able to make a determination as to, based on the perception, how the person is walking, whether or not they felt that the person was intoxicated. And what I would also encourage the board to do, because there has been other reports, and when I mentioned it, one of the board members remember, there was another report that we put out there where some officers were talking to a person, and the officers were having a discussion whether or not the person that they were looking at was intoxicated or had been on some type of drug. So if you think about it, remember the officer said, hey, are you on any type of medication? If you remember, there was an accusation of this person being called a pillhead. So I think you remember that. What the officers were trying to establish is, had you been on some type of medication, and if that's why that person was acting a certain way. So, you know, the officers, we do rely on the fact that because they do this on a regular basis, that they do have their own perception. But again, whether or not the statement that they made among themselves talking to make a determination would not have changed the outcome of whether or not the officers violated policy or procedure or was in policy and procedure with the discretion to be able to tow this vehicle.
Can I just have one more question about this? Would this be an example of, because they have several questions here, and one of them is, how did the officers make this determination? So initially, you all did not, because you were able to look at the body cam footage and just based off of the allegations. If you would have had these questions ahead of time, would you then been able to go back and actually interview the officers? Or is it once you've already done that, it's like, that's it, you just stick with the allegations?
Well, what we look at when we bring the officer in, and again, we are guided by the FOP contract, is the questions have to be narrowly related to what the allegation is.
Okay.
So what we would have said is, you know, bringing them in and asking them questions as to, you know, you made a comment that you thought the person might have been intoxicated. Was that going to be something that changed the outcome? And if it wasn't going to be something that changed the outcome or something that was narrowly related to the allegation, then we would not have brought them in to talk to them about that.
Thanks.
Moving forward, the other thing that I recommend is, when you're in your committees discussing these, if you have questions for the IG, whether you're going to agree with the finding or not, or just have additional questions above and beyond your finding, I would reduce them to writing and forward them to the IG in advance, so that at the next meeting, the IG can address them and incorporate the questions potentially into the report.
Yeah, it's helpful. Yeah, and I think and this was obviously, you know, less than 24 hours ahead of time, so thank you for getting the information and reviewing it, but still trying to think through our best process in terms of the subcommittees and how they operate and how we get questions over. I also want to say, like, you know, we're, you know, obviously in the specifics of each case and those types of things of when we have these types of discussions, while I know the practice has been standard, like subcommittees do their discussion and then like everybody else, as we review as a full board, kind of maybe ask one or two questions, but then we defer to the subcommittees, which I completely understand and agree, but trying to figure out where that space is where, the subcommittees get to have more of these types of discussions. It doesn't have to be at these board meetings, but maybe at certain subcommittee meetings where we can ask more direct questions. Yes, we'll write it down, but just because it's helpful to get a sense, and maybe it's easier to not do it on specific cases, but it's helpful to get a sense of how the investigators make their determinations about, okay, there's a complaint here, and this is how we're going to pick out specifically what we determine to be allegations from that complaint, and how those allegations are made. And the reason I bring that up is because if I were a complainant and I had allegations about something, and I might have further questions about why certain allegations were listed here and others weren't. So the question I have is when allegations are closed, those are submitted after the IG submits its report to the board. At that same time, is a letter sent to the complainant, or does that happen once the board forwards its recommendation over to the chief of police? That was just a question that I had.
So you had a question, you also had another question. I'm going to answer both of them. So the first thing is, how does the IG determine what allegations are investigated? We only investigate allegations that are a violation of policy. When the investigator contacts the complainant, because sometimes the complainant will give us a list of allegations. And what we do want the complainant to understand is that some of their allegations don't fall up under our jurisdiction, and then some of their allegations are not a policy violation. So we do let them know that. So in doing the investigation, once we're done, and then following on with your question, once the investigation is done, we send a letter out to the complainant, and they are advised that we received their complaint. Well, not that we received their complaint, but the investigation has been closed. And so what the findings are, we also let them know that it still has to go through the board review. So they do understand that there's another layer in there.
Excellent, thank you. So I've got my questions answered. Thank you for that. And I don't know, subcommittee, if you are fine with those answers, those responses. I think we just had further questions for the review there, and so with that, my concerns are addressed. So on this particular instance, on the two allegations, this was to be closed with a finding of exonerated for case number 0527. So I'd make a motion on case number 0527 for a finding of exonerated for these two allegations in agreement with the Inspector General's.
Second.
Any further discussion? All in favor, please raise your hands. Motion passes. Thank you.
Next, we have case number 0528. This case, we do have some further discussion. We'll keep it limited. In this case, the complainant filed a complaint with the Department of Inspector General alleging misconduct by Columbus police officers. The complainant alleged that the officers displayed unbecoming conduct by being rude and making him feel uncomfortable during a traffic stop. After review of body-worn camera footage and CPD policies and procedures, it is recommended that the allegation against the officers be closed with a finding of, quote, exonerated, as their actions and conduct did not violate any CPD policy, procedure, and or law. So in this particular instance, to the allegation itself of whether or not the officers displayed unbecoming conduct by being rude and making him feel uncomfortable during a traffic stop, our committee agreed with the finding of exonerated, but we had additional questions and concerns that were basically connected. They were not issued as a separate allegation, but concerns that we had. One in this particular case was when they had asked the complainant to step out of the vehicle to conduct a pat-down of the complainant for weapons, because the officers suggested that they had reasonable and articulable suspicion to conduct a pat-down. And in that particular case, the investigator cited a case number to suggest that the officers said they had reasonable and articulable suspicion to conduct a pat down. But we did have further question about how the investigator made that determination as to not just that the officer said that they had it, but how the investigator made the determination of whether or not there was reasonable and articulable suspicion in this case. I don't know if you had,
I have quite a few notes.
yeah,
on
yeah,
this.
and Pastor Tate, if you had a couple others if you want to point out.
For me, my concerns about this incident, I had questions about the officer's ability to make the complainant get out of his car and frisk him without seeing a weapon. Because I think if we read this, it said that they believed that he was sitting on a weapon. And I guess they quoted, what was it, Mims versus such and so on here. But I don't know, it just didn't sit well with me. I just wanted some explanation on that. And I guess our counsel over here, I guess he kind of hit on it a little bit with this other case that we dealt with. What was it, 4411 or whatever it was that we were dealing with earlier, where, they have the right to do such and so and so. But it's still just, because this was a totally different reason why they stopped him.
Yeah, and I think this is and I guess when we request further discussion, so I know there's the point generally of us making sure that we have everything in writing for the investigator and have those pieces, but then there are some things that as a board, and I think maybe with counsel to even just help us further clarify and understand kind of the determinations that are made when it relates to finding reasonable and articulable suspicion to conduct a pat down and kind of, we were just wondering how the investigator made that determination, because it said that the officer said that they had it, and then it cited Pennsylvania v. Mims, but it didn't really go into much detail. And that is a question of, maybe just in terms of efficiency, how much detail you all are going to go into in each of these, and whether or not that rises to the level, or if there's just broad authority that they have to what can be determined as reasonable and articulable suspicion. But that was one of the questions that we had related to this particular case.
I mean, you've got two paths you can take. The first path you can take is you can say, hey, reasonable suspicion is a legitimate issue that we need to worry about, but we recognize that the IG knows what she's doing and knows that reasonable suspicion is an issue and is going to do her due diligence to investigate that and talk to whoever she needs to talk to and review whatever she needs to review, and then just put a conclusion in the report that you're going to put some faith and credit in. Or the other path is you're going to question that, which you have the right to do if you want to, if something just doesn't sit well with you, if a particular set of facts and circumstances, a specific fact pattern, you're just confused, or it doesn't make sense, or you think there may be more to it, and you want to get some elaboration on it, you can ask for that kind of clarity in relation to that particular report that you're reviewing.
Great.
No, I think more to the point, I don't have any problems with the IG or her investigators, but what I do have a problem with is I'm trying to get myself educated as to how this process works. Because we got police officers that seem like they have more power and authority over the average citizen, then I know that some of my constituents are going to ask me, well, how can they do that? So I'm just trying to get an understanding.
Yeah, and I think that what's challenging for folks that are not in law enforcement or don't have that kind of background or experience is, like you said, understanding and realizing what authority an officer may or may not have. And I think there's a differentiation between things that you don't think maybe it doesn't sound right, doesn't look right, versus what they actually legally have the authority to do, or what's within policy versus what's not within policy. And then for the portion where you say they were rude, or it doesn't violate policy, but we still feel like they were rude, inconsiderate, poured fuel on the fire, those types of things, then the determination the board needs to make is whether that's worthy of forwarding to the police for further training, not necessarily discipline, but further training into those types of areas.
And if I can interject, I think one thing that we've talked about, but we haven't had, at least we haven't had in the last year, maybe even longer than that, but we have had offers from the city attorney's office to come and give the board updates on case law, and reasonable articulable suspicion is in and of itself rooted in case law. So all the factors that go towards it are things, and any new case updates, I do think we have the ability to ask to get the updates very similar to what CPD gets, because I know they get periodic updates when new Fourth Amendment case law comes
Yeah,
out. And
of
so
course.
I think we can also add that to our agenda to help root us in some sense of, if a report says RAS, then we at least know what the current case law is on RAS. And so that could probably cut down on some of the back and forths, or at least give us a more, a better way of saying, oh, okay, so when I don't know, when it says he looked like he was sitting up in his seat further than what was possible, or something like that, that could at least help us tie to what RAS standard looks like. And so I will write that down as something to
Yeah,
put
the
on our
other,
list of things we can have.
The other distinction I draw is you're reviewing complaints where both officers are called to a scene versus ones where the officers are initiating the scene or initiating the stop. And those are very different and distinct types of situations. So, for the ones where the officers are making the initial stop, reasonable suspicion is a very, very, very low standard. As long as the officer can articulate some basis of why they made the stop, usually rooted in a traffic violation or a vehicle equipment violation, they have the legal right to stop the person. And then once they do, there are limits in what they can look at and look for and how they conduct their investigation moving forward. And as they do that, if more information, more details arise in terms of establishing additional suspicion or probable cause, then that enables them to continue their investigation. But at some point in time, if they are finished with what they're doing, they need to just stop and move on and give the person the ticket and let them go versus calling a canine out, things of that nature. So it's very fact-specific. As a prosecutor, you use the phrase totality of the circumstances. So it's very fact and case-specific. It's hard to kind of put things in one particular mold or standard. You have to just independently review things on a case-by-case, facts-specific basis. But officers do have wide discretion when interacting with citizens.
Great. No, thank you. And that's helpful. And I think with those specific, that was a helpful way of doing this where, we'll have some questions that I think are specific with the investigators, and then also generally thinking about how we operate with counsel and where we kind of ask our questions or for further detail. I did want to make a note in this particular instance, right, where, the officer followed the complainant in his vehicle until he committed a traffic violation so that they pulled him over. There's discretion to do that. That happens. What I am noticing, and we haven't really pulled all of our cases together and kind of reviewed them all, but that does seem to be a pattern or a practice that occurs. It seems like there's discretion for that to occur, where the traffic violation, the traffic stop, then leads to a set of other things, or there was a goal to get to the set of other things, and the use of the traffic violation and stop helped them get there. I understand it seems that there's wide discretion, of course, to do that, but it is something that I just wanted to make a note of for our board to think about is, the types of cases and complaints that we're getting on traffic stops, because that has happened quite a bit. It's come up quite a bit around traffic stop complaints, and then some additional complaints around pat downs have come up. I understand that there's wide discretion, but as we try to think about our other charge as board members, really thinking about patterns and practices is something we should be mindful of. In this particular, yeah, go for it.
But traffic stops are used as a vehicle, are they not? Law enforcement does use traffic stops as a vehicle to stop a car so that they can figure out what's going on for other things.
Correct. I mean, given what you and I used to do for a living, it would be
Exactly.
naive for us to say that they don't. So, But that doesn't mean, I mean, again, all the IG's office can do is look at the body-worn camera, can look at the U-10-100, can potentially interview an officer, can talk to the complainant and witnesses, and gather as much information as they can to determine whether there was the requisite reasonable suspicion for the traffic stop. You know, to your point, I mean, if the person got ticketed for the traffic stop, they could go to municipal court and fight that ticket and go through a trial and have that adjudicated. But for purposes of these civil administrative types of proceedings, they can only work with the information that they have.
Yeah, and officers will say, I'm not going to give him a ticket. I only needed to stop the car.
Yeah, and so there's a variety of different instances. I think this is I think it's helpful for us to know, obviously in this specific case is one thing, and then also thinking about more broadly about these incidents and how they can occur, as well as the other avenues that the public has, right? There's one aspect is filing a complaint with the Inspector General's office, and then there are other opportunities that people, if they want to fight a ticket, for example, could go elsewhere. So that's helpful to know. I've got my concerns addressed in this particular instance, so thank you to all of you for that. And so that was the one piece that we had. So as it relates to case number 0528, for a finding, or the allegation was that the complaint alleged that 3 officers displayed unbecoming conduct by being rude and making him feel uncomfortable during a traffic stop. Our team agrees with the investigator's finding of exonerated for that allegation. And so I'd like to make a motion for 528 as agreeing with the IG's recommendation of exonerated.
Any other discussion? All in favor, please raise your hands.
Last one, there's not discussion here. 530. This is the complainant filed a complaint with Department of Inspector General alleging misconduct by several CPD officers who responded to her call for service. The complainant alleged that the responding officers did not handle the situation properly by failing to do anything. Quote, do anything. The complainant expressed that she felt as if the officers couldn't have cared less about the incident and that the officers didn't treat her fairly. The investigation revealed that 3 CPD officers responded to the complainant's call for service. After review of all the relevant evidence, the Columbus Department of Inspector General recommends that the allegation that the officer did not care or treat the complainant fairly be closed with a finding of, quote, unfounded for all 3 officers, as the investigation revealed no evidence to support this allegation. The Columbus Department of Inspector General does recommend that the allegation that the officers didn't handle the situation properly be closed with a finding of, quote, sustained for one of the officers, as the officer did not respond as outlined in CPD policy. And this is one of the concerns you had related to the fact that in this particular instance, the officer did not properly file reports in a timely manner. And so there was a violation that the officers did not respond as outlined in CPD policy and or procedure. There was no, if I recall, no specific additional recommendation given there outside of that particular issue is sustained on that policy. So that, I just want to make sure I've got that pulled up. I'll make sure I've got this. Sorry about that. Make sure. Sorry about that, folks. So that this report, and I've got to make an addition to this one, so that this particular instance is recommended that it is forwarded to the chief of police for review and consideration of disciplinary action in accordance with CPD policies and procedures and the collective bargaining agreement between the City of Columbus and Fraternal Order of Police, Capital City Lodge, number 9. And that is related to the fact that one of the officers violated CPD policy and procedure for the not properly requiring CPD documents. So, the final allegation, or the final disposition in this particular case is for a finding of unfounded for the allegations that the 3 CPD officers did not respond to the complainant's call for service and did not care to treat the complaint fairly, be closed with a finding of unfounded. An allegation, and then there is I don't know how we want to do this part. Do it separate?
This was founded by the IG separately?
Yeah.
Yeah, so separate motion.
Okay, so the first motion is that the CPD, that is agreeing in case number 0530 of exonerated for the allegation of not treating the officers or treating them fairly, of unfounded for that allegation.
That's been moved. Can I have a second? Second. Any questions or discussion? All in favor, please raise your hands. Passes. Thank you.
Thanks, Bethany. I'm sure you'll clean that up. I messed that up a little bit. I think we got that. Then I would like to make an additional motion for case number 0530, that this that there was a finding of sustained for the allegation that the officers didn't handle the situation properly, be closed for one of the officers as they did not respond clearly because they did not fill out the report properly.
I would also indicate in your motion that it's an IG-initiated allegation.
That is not, that's part of the allegation on the first one. That would be like allegation, the first, number one, that the allegation that the officers did not handle her call properly for service by not doing anything. And we're stating that one of the officers did not properly complete the required CPD documents.
Oh, I was under the impression that it was completely IG-initiated. If it was part of the initial thing, then you can include it in the initial motion. The way Mr. Strickland was articulating it
Yeah.
earlier, I thought it was completely IG-initiated and it was not part of the original complaint.
So yeah, no, it's helpful for one of the officer. Okay, I'm just trying to read. Yeah. I was sorry. It's difficult with some of the language. So I just want to clarify. 2 officers it was unfounded for both allegations for two officers.
It was just sustained for the one officer that was required to do the documentation. They didn't complete it.
Okay, and that's allegation 1.
Right.
Okay. I don't know what to do with previously.
Oh, so am I correct?
Yeah.
There were 2 allegations.
Yes.
For allegation 1, it was 2 out of the 3, it was unfounded, but for 1, it was sustained? And then
There were 2 allegations, and so what happened is when the investigator was looking at the report that was, should have been done by the officer,
Right.
it was not thoroughly done. So that was reason why we sustained that they did not complete.
There are
It
3
didn't-
officers involved here?
Yes.
Okay,
But-
so allegation 1 for 3 officers, 2, it looks like were cleared, and 1, it's sustained, and then for allegation 2, all 3, they're cleared.
For 2, yeah. 2 would have been unfounded for all.
For all
officers.
3?
All 3.
Right, so you just want to amend your motion, the previous motion, you just want to amend that to clarify that for allegation number 1, the finding was it exonerated or unfounded?
Sustained. Allegation 1 was sustained for one
all the
officer.
No,
officers?
for
No,
for
for
2 of the
one.
officers, was it unfounded or?
It would, yes, you're right. It would be unfounded for 2
Right,
of
so you
the
just want to
officers.
amend and clarify that for allegation 1, for 2 of the officers, it was unfounded, and for
Okay.
1, it was sustained, and which one it was sustained for, and then for allegation 2, it was unfounded for all 3.
Okay, that's helpful because what I'm reading here, allegation 1 is the complainant alleged that the officers did not handle her call for service properly by failing to do, quote, anything. And then under the recommendation section, it says, it is recommended that the investigation into allegation 1 be closed, quote, sustained. There's nothing here that indicates 2 of the, for only 1 of the officers. It seems like,
If you look down further where it says the recommendations part, it lists that it reveals what the officer did not do, and it also reveals what the officer didn't do up under the conclusion part.
So I guess the confusion I have is that it seems that there are 3 officers involved in this case. And in the recommendation section, it's saying allegation 1 be closed sustained. Is that maybe just in reference to one officer, or are we referencing all 3 officers?
Just one. It states, I'm just reading from the report, it just says, based on the information, evidence obtained and reviewed, the Columbus DIG recommends that allegation 1 be closed with a finding of sustained for officer,
Yep,
yep.
got it.
okay.
Okay, so that's helpful. Thank you for that. So that's under the conclusion part. Okay.
Right.
Okay. The conclusion is slightly different than the recommendation. I think you're carrying it forward, and you're only now talking about that one officer. That's helpful. I just misread that a little bit. So on that, I would like to amend the motion that I just made regarding case number 0530, which was that
I can repeat it if you want me to.
yeah.
For allegation 1, unfounded for 2 of the officers and sustained against officer, and then you'll have to identify the officer. And then for allegation 2, unfounded for all 3 officers.
Yes, so I'd like to make a motion on case number 0530 for allegation 1 to be unfounded for 2 of the officers and sustained for 1 of the officers that's listed here in this report. And then for allegation 2, it's a recommended of a finding of unfounded for all 3 responding officers, as there was no evidence that suggested that the officers did not care or displayed unbecoming conduct.
So the motion on the floor is to amend the previous. Do I have a second?
I have a question.
Yes.
I wanted to look at this because I had an issue with something that this particular officer said, and I know that the IG's department was on it, that it is common practice for them not to do these forms in a timely fashion. And I think that it's important that we make sure, that we make that known, in your recommendation, that we're going to say, go back to the police chief or whoever it's going to, because I have an issue with that it's a common practice that they do that.
And then part of the recommendation on this is that this being forwarded to the police chief, this part of the motion, forwarded to the police chief for the review and consideration of disciplinary action according to policies and procedures. You're exactly right on this point.
And excuse me, and I was just going to add, because if you look under the recommendation, just giving clarification to what Chair Tatum said, was with this, the officer was stating that it was common practice not to complete that. We were going by what the policy states. So you'll see in there, the reason we sustained it is because we went with the policy. However, part of our recommendation was that it be reviewed, and if it is a common practice, that we recommended that CPD either update their policy to reflect common or past practices, or re-instruct the officer as to what CPD policy states.
It's great.
And I don't want to belabor this, but the issue, what's good for the goose is good for the gander. If they're going to hold, if our police are going to hold the citizen accountable for law and what their policies are, then they should also hold the officers accountable for the policies pertaining to them and what they should be doing.
All right. Thank you, Team 2. I am going to pause and go out of order just for a second.
I don't think there was a second.
Oh, was there not a
There was no
second?
second,
Sorry.
and there was no vote on the amendment to the motion.
Thank you for that. So, second. All in favor of accepting the amendment, please raise your hands. All right, motion passes. Thank you. Briefly, sorry, Mac, I'd like to be able to make case assignments just in light of time, so that if our reviews take us all the way up to 5 o'clock, if we have cases left over, we'll push those to next week, but we don't want to miss the case reviews. So Bethany, if I'm going too fast, let me know. For Team 1, we're going to take 2022-0524, 2022-0542. This also includes 3 other related complaints that were filed. Case numbers 0543, 0549, and 0551. All were combined into one investigation. In addition, the last 2 cases for Team 1 are going to be 2023-0014 and 2023-0021. For Team 2, case assignments are 2022-0404, 2022-0479, 2022-0513, 2022-0534, and 2 more, 2022-0578 and 2022-0545. I think there's only going to be 1 administrative closure in this group, so apologies to Team 3 for this. Team 3 is 2022-0453, 2022-0522, 2022-0531, 2022-0599, and 2023-0015. Thank you, Bethany. Did you get them all? All right. All right, turning it back over to Mac for Team 3's presentations.
First case, 22-0383. A mother filed a missing report on her 15-year-old daughter, who was a frequent runaway. Officers were finally able to locate the 15-year-old. The mother ID'd the young lady as her daughter. Officers advised the mother to meet them at police headquarters, where they would be transporting her daughter for processing. The mother did not come to police headquarters. Before leaving headquarters, officers attempted 3 times unsuccessfully to reach the mother by phone. Officers then transported the juvenile home to the mother's residence. The mother and stepfather's vehicles were at the house, but there was no answer at the door. After a couple more attempts to leave the daughter with a family member or a friend, the officers transported her to the workplace of a family friend. The daughter ran away again, was later located and taken to Franklin County Children's Services on an unruly warrant. Her mother and father filed complaints with the DIG alleging the father of the child alleges the officers released his 15-year-old daughter to a non-guardian. The mother alleges the officers released her daughter to someone that will be or is being investigated for harboring her daughter. Based on BWC footage, interview statements, cruiser footage, CPD policies and procedures, the investigation revealed that there was no evidence of misconduct by the officers. The mother had the opportunity to take her daughter home with her had she gone to police headquarters after being told by officers that that's where they were heading. Officers were correct in leaving the juvenile in the care of the friend per CPD Division Directive 3.04 and ORC 2151.31A3. I motion that we, the board, accept the DIG findings of exonerated.
Second.
And I'm going to make a second motion for a violation, but
Okay. All right, the first motion has been first and seconded. Any discussion? All in favor, please raise your hands. All right, motion passes.
My second motion is for a allegation of violation for the use of profanity by an officer. A sustained allegation, that is. It's recommended that this investigative report be forwarded to the Director of Public Safety, Chief of Police, for review and consideration of disciplinary action.
It's been moved.
Second.
Just
Oh, I'm
repeat
sorry.
the case number.
Case number 22-0383.
Okay, we have a first and second. Any discussion? All right, all in favor, please raise your hands. Motion carries. Thank you.
Case number 22-0401. On October 19th, a citizen filed a complaint with the DIG alleging, allegation one, he alleged that the officer approached the complainant's vehicle, demanded he get out, and pulled him out of the vehicle. Allegation number two, complainant alleged his nose was fractured and he suffered other physical injuries when he was pulled from the vehicle and thrown to the ground. Allegation number three, when the complainant asked the officer why he was pulled out of his vehicle and thrown to the ground, the officer told him, quote, "Stop playing dumb, you know exactly why I'm here." BWC footage and further interviews and investigation by the DIG investigator revealed that the driver of the vehicle was in the company of two of his friends who were identified as having stole merchandise from the Ultra Beauty store. The merchandise had GPS tracking, which enabled officers to locate, stop, detain, and later arrest the two friends of the driver. BWC footage also shows after being stopped by officers, the driver was given verbal commands to put his hands up and exit the vehicle. The complainant was slow to comply. The officers pulled him out of the vehicle by his left arm and forced him by his shoulder to the ground. Later, a medic was called and diagnosed the complainant with an abrasion on his shoulder. The complainant at no time gave notice of a nose or any other facial injury or discomfort. Officers used enough force necessary to control and cuff the driver. There was also no evidence to support the complainant's allegation that the officer said, "Stop playing dumb, you know exactly why I'm here." The officer did use profanity towards the complainant, which is a violation of CPD work rules. I motion that the board accept the findings of the DIG of exonerated from allegation 1 and 2 and unfounded for allegation number 3.
Second.
Any discussion? All in favor, please raise your hands.
I also motion for a second or a separate and sustained allegation of the use of profanity by the officer in violation of CPD policies and procedures, and forward this case number 22-0401, to the Office of the Safety Director and Chief of Police for further consideration of disciplinary action.
Second.
Any questions? All in favor, please raise your hands. Thank you.
Case number 22-0421. On October 26, 22, the complainant filed a complaint with the DIG alleging that he was skeptical that a welfare check was conducted at all when he called for one on September 27th, 22, after he saw a package still on the front porch of the home of his neighbor. The DIG investigator requested a CAD report. The report showed that the officer did in fact respond to the request to check on the well-being of the complainant's neighbor. The officer states that he walked around the home, knocked on the front door, rang the doorbell, but there was no response. He also checked the windows. All the blinds and curtains were drawn. He walked around the back of the home to ensure nothing was amiss. The officer is familiar with the residence, and it's not out of the ordinary for no one to answer the door. The BWC of the officer supports his actions. I motion that we, the board, accept the DIG's findings of exonerated for complaint number 22-0421.
Any discussion? All in favor, please raise your hand. Motion carries. Thank you.
22-0425. October 27th, 22, the complainant files a complaint with the DIG alleging 2 allegations. First, she stated officers asked her to spread her legs too wide during a search after she informed them she needed to use the restroom. Allegation number 2, she stated that the sergeant raised her arms all the way up her back while wearing handcuffs, causing her wrists to be bruised. A review of the officer's BWC, CPD policy and procedures by the DIG investigator as it relates to allegation 1 revealed that asking a person who is under arrest to spread their legs a little wider in order for the officer to conduct a search does not violate CPD policies or arrest procedures. As for allegation number 2, BWC shows while the officer searched her, she continued to move, prompting the sergeant to grab her left arm and place his foot near her right foot to prevent her from moving. The sergeant then raised her hands away from her backside, which didn't appear to be too far away from her mid-back. She did yell that he was hurting her wrist. However, she admitted that her wrists were injured during a physical altercation she had earlier with multiple females. The sergeant was, however, found to be in violation of CPD Directive 11.07 by not activating his body-worn camera. And also Rules of Conduct 1.36, unbecoming conduct, stating good after she stated, "You're hurting my wrists." She then said, "You want to break them?" To which the sergeant said, "If I want to break them, I will break them." Those comments could be considered insinuating and unfavorable. I motion that we, the board, accept the DIG's findings of exonerated for allegation number 1 and unfounded for allegation number 2.
But wait, are you gonna do
Yep.
another one for the other?
Yep.
two? Oh, okay,
Yep.
okay.
Can you clarify just real quick with allegation 1 and allegation 2?
Okay, allegation 1 was asking her to spread her legs a little bit wider during the search. Allegation number 2 was she claims that he raised her arms way up her back while wearing handcuffs, causing her wrists to be bruised. Her wrists,
Yeah.
okay.
So in this particular instance, for me, allegation 1, kind of without the context, without everything, seeing it seems like that could be exonerated. But when you add the added context of the officer displaying rude and discourteous behavior, is that, I just.
If you're talking about the rude and discourteous behavior verbally, I'm with you.
Yeah, and so I'm just.
Third one, that's not the second.
Well, I know, but I'm just saying, it seems like they have the wide discretion when it comes to the first allegation.
of asking her to spread her legs?
Yeah, and then was he being rude and discourteous when?
Oh, when he asking her that? That's not what she's alleging. She's not alleging that.
Okay.
And the rude and discourteous behavior didn't come from her. That came from the IGs,
Yeah.
from his comments.
Okay. And I guess, okay. And I guess I was just determining how the determination was made that allegation 1 is exonerated.
Because he did ask her to spread her legs wider. I don't think she even did that, and they continued the search anyway.
Okay, got it. It's helpful. But that's just in the, okay.
Okay.
That was
So we've got a motion and a second, at least on those first two.
Yes.
Not yet touching the allegation that the IG initiated,
Right.
right?
Right.
Any other questions? All in favor, please say aye or raise your hands. All right, motion passes.
All right. Separate motion. Let me see, I'm sorry, my case number 22-0425. Separate allegation of failing to activate his body-worn camera in violation of Division Directive 11.07. And also ask that the case be forwarded to the Chief of Police, Safety Director for further consideration of disciplinary action on that particular motion.
Okay, so that one was sustained as well.
Sustained.
Okay, we've got a motion and do we have a second? Second. Great, any questions? I imagine we will have a third one coming.
Yes.
also. Yes. All right, all in favor, please raise your hands. Motion passes, thank you.
And the last separate allegation of, and sustained allegation, unbecoming conduct, violation of rules of conduct 1.36, making statements good after the complainant stated, "You're hurting my wrist." And she stated, "You want to break them?" To which the sergeant responded, "If I want to break them, I will break them," in violation of that CPD rules of conduct. And also, again, forwarding this case number 22-0425 to the chief and the safety director for consideration of disciplinary action.
Second.
Thank you. All in favor, please? Any discussion?
Yeah, so in this particular instance, it's for consideration of disciplinary action. I know in the past, we've actually recommended disciplinary action or training in this particular instance. So I don't know if, seems like those statements, certainly a violation of policy, and I just don't know if anybody on the board wanted to actually make a recommendation for disciplinary action.
I don't think we know.
I was going to say, the line, it's kind of, I don't want to say semantics, but I'm going to say semantics. If it's going to the chief of police, safety director, whether it's going to be for consideration of discipline action or recommend discipline action, it's going to go through the same process in terms of chain of command and how it's reviewed in progressive discipline along with the FOP contract.
Yeah, and I'm checking some of the other reports where we have sustained findings, and they all use the same language, consideration of discipline, I think because, again, it goes through that whole chain of command process, and that's what our recommendation is, and then if they move forward, they move forward with it.
If that's in conjunction with a sustained finding as well, that's hopefully good information for them when they're looking it over. But again, if you,
Yeah,
And if you want to
Yeah,
need
I
to
think I would
amend,
amend to recommend disciplinary action, and then we can do all the conjunctions and whatnot, but I think I don't know. We're trying to figure out a way to sustain an allegation, because anybody can say, okay, I'll consider it. And the reason why I say that is because if we wanted to track where there's departure from whether or not the chief of police issues, agrees, rejects, or modifies the decision of the board. In one instance, we made the recommendation for disciplinary action, and then, maybe there's a determination that there will be no disciplinary action. That seems to be a departure versus consideration of disciplinary action. The board itself never actually recommended anything, just said, consider it. And whether or not, they considered it doesn't necessarily help us track. And again, I know there are reasons to and pieces that make it whether or not discipline is moved forward, but I think from a board perspective, I would just amend it to say recommend for disciplinary action.
So then can we just amend the word consideration and insert the word recommendation
That would be my amendment.
Sure.
for disciplinary action
Yeah.
in case number 22-0425? Is that
Yes.
acceptable? Okay.
All right, we've got a motion, first and second, now a motion amendment, second. Any other discussion?
No.
All in favor, please raise your hands. Motion passes.
All right.
And Board Member McIntosh, I'll let you know that I will put a stop at 4:55 because we do have from referrals from Chair or Board Member Younger that I'm going to potentially be initiating or asking the board if we want to initiate 2 additional investigations or 2 additional complaints. So I want to make sure we have time to do that on the record.
Got it. Case number 22-0429. October 28th, 22, a complaint was filed with the DIG which alleges, there's 5 different allegations. First allegation, the complainant claims officers took her marijuana prescription and impounded her car due to the arrest of her daughter when she should not have been detained. Allegation number 2, and this is the daughter's allegation. She claims she was arrested, released, and then arrested again after she was told she could leave the area. The mother claims her daughter was asked to move her hands in a praying position in order to be handcuffed, and she feels that this is a religious concern. Allegation number 3, the daughter stated her vehicle was searched without her consent. Number 4, this is the boyfriend, claims his weapon was taken by police when it should have been returned to him. And finally, number 5, the daughter stated racial comments were made by officers regarding her boyfriend's name. BWC footage from several officers reviewed by the DIG investigator shows a vehicle parked after hours at a park, Portman Park. Officers approached the vehicle and observed 2 occupants sitting in the back seat, the male and female, boyfriend and girlfriend. Officers asked the female if she knew the park was closed, and shortly thereafter asked if any weapons were in the vehicle, for which finally the male half stated, yeah, it is. Officers get both the female and male out of the vehicle, detain and cuff them. In the process of cuffing the female, she was asked to interlace her fingers as if she was praying. This is verbiage used by CPD, sometimes by CPD, in order to be clear as to how the officer wants your hands, not meant to be derogatory towards any religion. Officers recovered an assault rifle. Officers also smelled the odor of marijuana while searching the vehicle. While searching the vehicle under the driver's seat, also located the female's purse. They retrieved her driver's license along with 2 joints and another container labeled Animal Fire OG, containing more marijuana. The vehicle was towed. The female is charged with illegal transportation of a firearm. The male is charged with illegal possession of a firearm. The firearm and marijuana is placed in the property room for evidence and safekeeping. Now, let me go through the allegations real quick. Allegation 1, the officers took, and this is the mom talking, took marijuana prescription and impounded her car due to the arrest of her daughter when she should not have been arrested. Vehicles can be legally impounded when drivers are arrested. Marijuana from the daughter's purse was taken to the property room. Allegation number 2. The daughter claims she was arrested, released, and then arrested again after she was told she could leave the area. She was actually detained. She was released and then detained after the officers talked to the gun unit the gun crimes unit detective who wanted her detained and brought to police headquarters to be interviewed about the weapon, for which she was later charged for illegally transporting that weapon. Allegation number 3, the daughter said her vehicle was searched without her consent. The officers don't need to consent, do not need consent to search after an arrest. Allegation number 4, the boyfriend claims his weapon was taken by police when it should have been returned to him. He was told that he was not old enough to possess a firearm. He was only 20 years old. And it was illegal, and it was legally transported, which he stated he understood. Nor was it legally transported, to which he stated in the BWC footage that he understood. And allegation number 5, the daughter stated racial comments were made by officers regarding her boyfriend's name. The officer simply asked how his name is pronounced. There was no evidence of the officers making racial comments on the BWC footage about his name. So, I motion that we accept the IG's findings of, let me see, it was, yeah, I just want to make sure I get them right. And I think it was exonerated on all.
1 through 4, it looks like.
I'm sorry, exonerated on allegations 1, 2, 3, and 4, and unfounded on allegation number 5.
Second.
Any discussion? All in favor, please raise your hands. Motion passes. Thank you. All right, Board Member McIntosh will save the remaining 3 for Team 3 for our next month's meeting, and you'll just go first before the rest of the teams.
I think we request that we get to do our whole report then.
I'm fine with that. I did want to take a moment, and we've done this before, so I'll do this similarly. IG Hendricks, we do have a request for 2 potential complaints. What I'll do is explain the incidents, the dates of the status that we know, and ask whether the office is aware of any complaint being filed. And we can kind of move from there if the board wants to initiate a complaint. The first involves the shooting, police officer involved shooting of Michael Cleveland, which happened on February 5th, 2023. That's been a little over 30 days ago, and we know that there's a 90-day time clock kind of running from date of incident. To our understanding, BCI&I already has this incident in their hands, so they're conducting an investigation, but we wanted to check and first see whether a complaint has already been filed concerning that event.
Yes.
It has been, okay. So, Board Member Younger, is that sufficient since we know a complaint has been filed? Okay.
That's fine.
Does-
Sorry, if somebody withdraws the complaint, you guys would still kind of move forward ahead? I just wanted to make sure in terms of how, because I think if we file the complaint, for example, I don't think we'd withdraw the complaint if there's an initiated complaint. So I just wanted to get clarification. If somebody files a particular complaint like this, do you have enough information to proceed with the full investigation?
Absolutely.
Got it.
We will.
Yep, they know the name of the officer, they know the allegation, and I believe Mr. Cleveland was hospitalized but since recovered. Is that correct? So as far as being able to get additional information,
Yeah, we actually have 2 complaints,
Okay.
and the reason we have 2 complaints is because each complaint provided different information. So with that, we would keep both complaints open. I think you assigned a case that one of the teams will see had a couple of complaints attached to it, although we did 1 report. but because all of the allegations and the different complaints were different, we just wanted to address them in one report. So to your question, yes, we would probably, if there's something different that comes out, we could possibly, but the complaint would not be closed. It would be something we would investigate. And we have it on administrative hold right now.
Okay.
Great, thank you.
Thank you. The second incident, which was a police-involved shooting which resulted in the death of Mr. Brett Andrews, that occurred on February 11th, 2023. There's also, or I'm asking, has there been a complaint related to that incident?
I don't, right now, we're checking. I know you said Andrew. What was the first name?
Brett, B-R-E-T.
We see anything?
No.
We don't see anything.
Okay.
there, no.
I'll present it to the board, at least with the information we know. Board Member Younger, if you have additional information. To our knowledge, there was a man who was from a different county, came into Franklin County, or came into Columbus, was a suspect of a case, ended up being shot. I don't know all the details about it, but because there's the potential for a complaint to arise, and we were made aware of it, I wanted to present to the board whether we, as the board, want to move to have the Inspector General investigate a complaint related to that shooting death. It appears to have happened on February 11th, which was a Saturday. I believe the identity of the deceased was discovered on February 13th, as well as additional details regarding the shooting.
Yeah, the BCI has the investigation of this shooting right now, but SWAT was involved, and Brett Andrews of Athens, Ohio, was shot around 8:20 p.m. on a Saturday following an encounter with the SWAT officers. And
So his name is actually Brett.
Brett Andrews, right.
So you're still asking for a motion?
Yes.
Okay.
Yeah, it doesn't
So
look
that's
like
what
they
she was
have any
asking.
complaint
Oh,
related to.
right. I
We
would,
don't have anything.
Okay.
do you have anything?
We don't have any, we didn't receive a complaint.
Oh,
So
okay.
there's nothing in our
I would
database.
I would make a motion that this would be investigated after, by the IG's office after BCI completes its investigation.
Okay, and I'll just amend to say, I think we just ask for the complaint, and then they'll put it on hold until BCI
Okay.
is done.
All right.
Do we have a second?
Second.
All right, any other discussion?
And just a quick question for the IG. For these incidents, and Dr. Jones, you had a name for it, not necessarily killings, homicides, but yeah, all these incidents, critical incidences. Is there a vehicle in the IG's office to find these, or how do we go about making sure that we don't miss any, so that the 90 days doesn't just, expire?
And kind of the question I have,
Sure.
when it comes to BCI kind of investigations, like, if there's a process in place that triggers, or if there's a practice by the office to review, or you just, I know there's a specific charge, right, in terms of where you could initiate, who initiates complaints, but that was something that has come up several times from this board, and so it's important just to make note of, how you all track that, or if you're waiting to see the complaints that come in.
Well, we don't have anything in our office right now where we're actually tracking that type of information. So if the board becomes aware of it and it's something that they want us to look into, definitely we'd be happy to. We can always put something in place, but we're just not aware of everything that does occur.
So we need to figure something out.
So yes, we can, but I believe right now, and this is part of what can also be covered in our legal update, there is a way to notify, but we'd have to be very specific about what critical incidents we want. So example, do we want every time a person is shot? Do we want every time a person is shot and it results in death? We just have to be very specific, because if it's every use of force, that's going to be too many.
Yeah.
Right?
Yeah.
So I think that's something we can ask notice to be given to the IG. You know, there's already reports that are available. It's just a matter, I think, of connecting with the IG to see what sorts of things might trigger that. That being said, we still have a motion on the table. Does the board want to have the IG open a complaint following the death or investigating the death of Brett Andrews? All in favor, please say aye or raise your hand. Okay, thank you. Motion passed. I wanted to make sure we actually close that loop. So I think that's an issue that we can definitely set up a process for. I want to say that was one of the processes that Chair Jackson asked Board Member Strickland to talk about, because it was one of the things that came up in the repeated conversations. What are some solutions? That,
Just on that note, so I did send a set of process and procedures to Chair Jackson and Vice Chair Burns, and also will be made available to members of the board related to additional recommendations, in addition to the IG's office recommendations that hopefully we can discuss at a future meeting, that touches on some of these points about how we figure out our process points. I also want to say thank you to the IG's office, the work that folks are putting in. Really appreciate that work. I know we asked a lot of questions, but I really appreciate the work of you all and the investigators, so thank you.
Thank you so much.
and before closing, please make sure you've got your case reviews. If there are questions you have that are clarity related and that can be simply asked to the IG's office or the investigative staff, please do your best to ask those ahead of time so that we're not asking them to go back and pull up something, and then that takes additional time, but that they can be prepared to say, here's what the answer is. So that way our meetings can be a bit more efficient. Yes.
I would like to also thank Mr. Tobias for being able to bring clarity from a legal perspective to this board, because that's what I want to get. I want to get clarity and understand. So when people ask me questions, I can speak from a point of knowledge and not stupidity.
Yeah, because it's helpful, because our subcommittee meetings, we have these discussions, we have questions. That's one thing, the written questions are important, but then also thinking about how we put in place a process to, whether it's at our subcommittee meetings or not, but it's helpful to have the support of council on that as well. So it's just one thing I wanted to put out there in terms of how we set this up.
Yep, and I'll work on reaching out to the city about having our legal updates, because I know that's a topic we talked about having, but we just haven't had the chance to. But I think it would be helpful, especially as it relates to Fourth and Fifth Amendment.
I'd say I'm not just available the one day of the month at these meetings either. You can feel free to email me at any time. I'm happy to provide my cell number. I mean, I'm pretty much 24/7 for all my other clients, so I'm happy to do
Yeah,
it.
and I have actually taken him up on that, so please feel free to reach out. I will now entertain a motion to
Madam
adjourn.
Chair, before we adjourn, I would like to state for the record our thanks to Bethany.
Bethany.
Yes.
For her work with the board, and wish her best on her future endeavors.
Absolutely.
Motion to adjourn.
Second?
So moved.
All right, all in favor, please raise your hands. Thank you. This meeting is adjourned.